everyone. How lovely to see you all. And with that, we're going to call the very first case, and it is Appeal 223190, Protect Our Parks versus Pete Buttigieg. Come on up, Mr. Epstein. How are you, Professor?
Well, we'll find out in about 15 minutes. Now, I want 15 to reserve 5 minutes of time.
Oh, you've got it.
And
Yeah.
I don't know how I manipulate the clock in order to achieve such stupendous aims.
It's a very clever item, and I will stop you.
Oh, I'm sure of that.
I will leap off the bench and push you back.
Okay, thank you very much.
Hear that? That goes for you, too.
Okay, fair is fair. May it please the court, my name is Richard Epstein, and I'm counsel for the appellants in this case. We have 3 separate causes of action that we're trying to address in the 15 minutes. The first of these has to do with the summary judgment that was issued by Judge Blakey against us in January of 2022. The second has to do with the reprise over the public trust arguments that have been made several times. And the third has to do with the review of the denial of the preliminary injunction that this court issued in July this year. So let me start with the first of them. What happened is
Could we start with the last?
What, the environmental case?
No, but could we start this way? If we begin with the assumption that we still agree with the reasoning in our decision denying the preliminary injunction, what, if any, of the federal claims remain here that were not addressed and decided in the prior appeal?
I think the prior appeal pretty much exhausted the waterfront on the claims that were presented. The arguments that we have with respect to that is we think there were some serious mischaracterizations in the earlier opinion about the way in which this thing went. I thought to put that off to last, not because it's least important, but there has been no record whatsoever on the first of these claims having to do with the question as to whether or not they satisfied all the condition precedents in the contract as to whether or not they're entitled to close, as of they did on August 16th, 2021. And it was a very odd proceedings. What happened is there was an exchange of letters, which is the only information that we have on this, in which we said that we did not think that they satisfied all of the condition precedents. They sent several responses to us, and then we filed our papers with Judge Blakey. They were filed on January 5th, and on January 6th, the next morning, he issues a summary judgment against us, does not allow us the opportunity to amend our complaint, which we did not need to do, and he denies us our case on the grounds that we are pleading a third-party beneficiary count, when in fact we never pleaded that at any point in our particular case. What we pleaded is this was another version of a derivative action or an individual action to stop the city from essentially entering into a contract which was disadvantageous to it, because all the condition precedents that had to be satisfied before they could get forward were in fact not satisfied. And so what we'd like to do is to go through the various issues that we put in that case in order to make clear why it is we think this is a valid concern. Well, it turns out that the basic contract has 3 major provisions that I'd like to address. The first of these has to do with the question of did they receive sufficient funds in order to close the deal with respect to the construction. The second is whether they had created an endowment for the sole purpose of dealing with this issue, which was sufficient to cover the future costs. And the third was whether or not they had to revisit the issue of whether these conditions precedents were satisfied just before they closed.
So before you get into those 3 points, I would appreciate your spelling out a little more how this is a derivative action. It's obviously not a corporation. You're not shareholders of a corporation. It's not, as previous opinions have held in this case, it's not a common law trust where you're beneficiaries. How do you see it as a
It's exactly
derivative
the last.
action?
If you go back and look at the precedents in this state, what they say, and we quote the briefs in the opinion, is that this is in fact a situation where the citizens are entitled to block any transaction made by the state.
I don't see any authority from Illinois that says that.
We cite the cases in Illinois law which deals
I
with
looked
this.
at those cases. I just don't see where that turns into a sweeping citizens' right to sue that would go well beyond federal concepts of standing.
Well,
Maybe
the
the state
point is
allows
the
them.
standing in the case is not achieved by this. It's achieved by what we did with respect to our general pleas and with the supplemental.
Standing needs
jurisdiction.
to be addressed one claim and one form of relief at a time.
Well, I'm
So
trying
you
to do.
still have to, well, with the derivative, the so-called derivative claim, go ahead.
Yeah, no, but it's the cases say, as they did with respect to Pepke, that either you allow some citizens to maintain these particular case, or in fact the redress will not be possible
What,
on
what,
any.
what do you view, I'm sorry to interrupt, what do you view as your best Illinois case to support the contention that you're making?
Well, I mean, I don't remember the names right now, but they're cited on the first 2 pages of our brief.
Well,
And I mean, if you
Which
like-
pages?
Well, I mean, Pepke certainly does this because what it said was, when it overruled the earlier case called Dropsy, we have 2 alternatives. Either we could deny citizen standings, and we understand you can't get into federal court on that, and we didn't try to do so. Either you deny citizen standing, and you have no remedy whatsoever, or you allow citizen standing. So the last time round, when we were up here, the standing arguments were decisive. The case had not been pleaded correctly. At this point, there's no doubt that we have essentially federal jurisdiction over these cases. And as they did in the Lake Michigan case, they decided not to look at the federal claim first, but they looked at the state claim having to deal with the public trust doctrine. And the alternative is, we're just trying to say that this agreement turns out to be one that was not satisfied, and if we cannot raise this charge, then in effect nobody whatsoever can challenge anything that's been done by the city, even when it turns out that the claims that are made in this case show that everything is seriously askew.
Well, I understand that frustration. It does happen in quite a few cases where
But not this one.
standing is lacking. I will say I'm having trouble squaring your reliance on Pepke with what then Judge Barrett of our court wrote in the first round, where she says that you're relying on Pepke, and she says their argument disintegrates, however one reads more than the snippets they cite. Pepke is particularly devastating, she goes on to say. I'm sure you know the
Yeah,
sequence.
she's flatly wrong. Inexcusably
All right.
wrong. Let me explain why she is wrong. It turns out we didn't quote snippets. She quoted snippets. What we did, in effect, was to quote 3 major passages in that opinion. The first of which said, to give meaning and vitality to the clause, you must allow citizen standings to challenge it. The second was the exhaustive list of factors that went through in this.
When has the Supreme Court ever said that there always must be some default citizen standing? It seems
What?
to me that there are
We don't
countless
have.
cases.
We're not getting standing in federal court on the citizens' ground.
But
We're
as
get-
Judge Hamilton said, you have to tie it to the particular claim. You have standing for some claims, but this one, based on a contract between A and B, of which you are not a third-party beneficiary, however you would characterize it, you're just a stranger to that action.
No, we're not. This is a situation done by a public body. As Pepke said, that public body turns out to be a trustee for all citizens. We are essentially saying that there's both aggregate, rather derivative and individual standing on this particular case, because otherwise what happens, you'll never pick up the clam and look to see what's underneath it. And in fact, what's underneath this is a massive irregularity. If you look at what Justice Blakey said, he did not talk about standing a jurisdiction. He gave a final judgment on the merits against us in this particular case, and the only way he could do that is to assume that we had standing.
Well, but he didn't. You certainly understand that we need to make sure all that.
I
those
understand,
bases are
but this
covered.
is...
Whatever Judge Blakey, who
Well,
we
we
all love,
understand
you
that,
know,
but whatever
nonetheless.
happened in this case is so long as we get into federal court, they're standing, and then what happens is the claim that we're raising is either individual or derivative ability to account for it, because otherwise what you're saying here is we're alleging very substantial irregularities with respect to this case, and we're saying that nobody can review it. This is not the way constitutional government works. And so what are the mistakes that they made? Well, the first one is they said they just had to receive some money. They said they had received $482 million on a 485 base. That was an unordered account, $3 million difference. And their view is it was okay to receive the money, but you didn't have to save it or put it into a special account. Their position was you could spend it on other things. They do not have that money in the particular account. And so that's a clear breach We think of what's going on. We cited in support of that Wood versus Wading Duff Gordon, a case which has been adopted in Illinois. And it all says that you have to be efficient in the way in which you do it. This is a security agreement. If you receive the money and dissipate it on other functions, it doesn't provide security.
That's speculative. at
No,
this
it's not
point.
speculative.
Have you
That-
any idea of what those functions are?
Do I have any idea of what?
Of what the functions are that the money was spent on?
Yes, the money, we don't, but it doesn't matter. The point is it's not available to build the building.
So,
And the
Mr.
second-
Epstein, can I ask you a question about this taxpayer derivative theory? I confess, I've never seen an actual viable relief won on this theory. But do you think that if you're trying to kind of borrow the derivative concept from corporate law, that there's anything like the business judgment rule that would apply to government officials who may decide, for example, well, we have this contractual right, but we don't want to insist on it?
No, there's not in this particular case. For two reasons.
Absolutely rigid, then.
No,
That
I'm
the-
not
the-
rigid.
the-
The first thing is they refuse to claim that there was any waiver of the particular condition in this case, so they're standing on the original contract. And secondly, this is a case of a clear breach of a specific duty. It's not a case of judgment whatsoever. It's-
Any corporation that has, let's say, a contract with its supplier of essential inputs has to have the discretion to waive or modify contracts, right?
No, that's not correct.
It's not.
No, because some cases time is of the essence, and in this particular case, the contract affords a remedy to them. If they cannot meet the condition precedents, they're allowed to defer performance of this particular
So
contract
I'm
without penalty.
struggling. I'm struggling, Professor.
What?
I'm struggling with the idea, you want to borrow from corporate law this notion of derivative relief on behalf of
Well,
shareholders.
that's what the state of Illinois does.
Well, it has referred to it. I haven't actually seen cases where relief was won, and I don't know how you have standing in federal court on that. But put those questions aside. If you get to the merits, in any corporate law setting, management, here we would say the government officials, has pretty broad discretion, not complete, that's why there is such relief available, but broad discretion to use their judgment in the best interests of the corporation, and that can include choosing not to insist on strict compliance under a contract,
That
right?
is not correct. The correct rule
That's
is
an
the business
extraordinary
judgment
assertion.
rule does when it turns out that there is some indefinite standard. This is a case in which the contract contains a condition precedent which is strict.
And a corporation can never
Well, they can
waive a
always
condition
waive
precedent?
it if they do it, but what happens is if this is a derivative suit, which we're bringing, they waive it, they have to show in fact that they're getting full and fair consideration from it. The reason the clause is put in there and the reason the clause is put in with respect to the endowment thing is to make sure that the city is not going to be on the hook for many, many dollars. Now, at the endowment, they take the utterly implausible position that putting $1 million into an endowment fund that required at the time $470 million was in fact to endow a fund. That has never
I
been...
want to back up, though, and get you to explain to me, whenever the city of Chicago enters into a contract, I'll just use the city, it could be the Park District, it could be anybody, but the city. Let's say they enter into a contract with a company to provide snow removal services. Are all the taxpayers of Chicago derivative beneficiaries of that contract because the snow removal will allow them to drive down the streets?
They are derivative, but they have to have a cause of action.
Can they sue the city if it is late in the payment, or the contract doesn't furnish enough trucks, or
No,
there's some
I think
flaw?
the answer in those cases is
So
not...
I'm trying to figure out which contracts fit in your group of derivative enforceability, and which contracts fall outside that line.
This is a contract on a major issue in which we're claiming on the paper record that there's a serious default.
But
There is-
you're saying like it's just big, but we understand, we see plenty of big cases, you know, it could
No,
be a
it's
big
not
contract.
just big. It's a strict condition precedent. And when there's strict condition precedents, those are exactly the kind of cases for which you should allow relief, because
But
it's not going to
if
be
one of the
discretionary.
other parties to the contract, if the counterparty to the contract wanted to get out of it, then I think you've described a perfectly good way that they can get out of it. It's the strangers to the contract that I'm worried about.
Well, no, it turns out that is not the case. Because what will happen in this particular case is then there's another clause, just to put it at the end, which says they have to do the financial review again before they can close. Absolutely standard. These are non-waivable provisions, and they never did the second review of this case at a time when we knew that the expenses involved in this case had in fact gone up at least
I understand the disconnect that you see, but what I don't understand is why, as a matter of the law of contract, that allows a perfect stranger to come in and upset the deal if both parties are willing to waive.
Because the answer is
the
ours
functions
is not
as-
a breach of contract claim. Ours is a claim for breach of fiduciary duty,
Well-
which in fact under Drosky, every single person could raise. Now, you're talking about cases where people want to raise it, but those are exactly the cases where there's no probable reason and nobody's ever done it. But I could say there has never been a case like this one where there has been such a fast differentiation. The basic situation, if you put all the numbers together, is there is probably over $1 billion shortfall in this particular project that they continue to build. And this is simply not tolerable when you're running this kind of a situation.
Did you say 1 million or?
No, billion.
Hmm.
Because they have
Well-
$1 million in the $470 million trust, and the building cost had gone up by at least $200 million. And this is as of 2 years ago. There are no updated financials that have been released by the Obama Foundation. We don't know anything that's going on. I'm going to stop at this point. I'm sorry.
I'd like to ask you one more question before.
Okay. I hope it's.
I'm sure
Don't-
the presiding judge will be
I will.
courteous
I will.
to all counsel here. My question is, if this case is not moot, what would injunctive relief look like at this point?
At this point in time, you would have to stop all construction until one could satisfy that they satisfied the condition present. There
Well,
is
you've
no
also,
option under this
you're
contract but
seeking, Professor,
What?
you were also seeking a complete prohibition, right, on completing the construction that on other grounds, apart from the financial
Well,
considerations,
no,
right?
to be more technical about it, on the environmental claims, we are claiming that the original preliminary injunction was incorrect and should have been decided the other way.
Right.
That does
Do
not
you
require- that
want
requires a
the
full trial.
construction dismantled?
No, that may be ultimately the case, but at present, we're not asking for that. We're asking for a complete environmental impact statement to be performed, and in the end, to slow this particular production.
In other words, you want a complete stop
I'll stop.
to the building. No, not you.
We want to stop the construction
Right.
until they prove that is consistent with that, and we want to stop the construction until they prove that they're in compliance with the public trust doctrine. They are not, because all they can say is that it is legislatively confirmed, and they ignore all the constitutional constraints that are found in PEC.
Okay, now I will add what we took up, and I just want you to know that I didn't hear you. And when you said 1 million, no, you said 1 bill, and I understand that I had misheard you.
Okay, I'm sorry.
No, it's me, not you.
Okay, thank you very much.
Okay, okay, thank you.
Bye-bye.
Bye-bye for now. Come on, who's coming first? Ms. Tischer?
Good morning, Your Honors. May it please the Court. My name is Elizabeth Tischer. I represent the City of Chicago and will also be presenting argument on behalf of the Chicago Park District. This morning, I will be addressing the state law public trust, non-delegation, ultra vires action, and constitutional claims. Ms. Tacey Flint will be presenting argument on behalf of the Barack Obama Foundation and will be addressing the leave to amend issue regarding the breach of contract claim. And Alan Braybender will be presenting argument on behalf of the federal defendants and will be addressing the federal claims.
Okay.
This appeal marks the third time plaintiffs seek this court's review of claims challenging the construction of the Obama Presidential Center in Jackson Park. And in this iteration, plaintiffs add nothing new to the theories this court has already rejected. Instead, they ask this court to depart from every decision that has come down against them. The district court's judgment should be affirmed. Turning first to the public trust doctrine, the Illinois Park District Aquarium and Museum Act easily disposes of that claim. In 2016, the General Assembly amended the Museum Act to include presidential centers, along with the other museums that could be located in public parks. That purposeful act reflects the legislative intent that presidential centers, like other museums, serve valuable public purposes, including furthering human knowledge and understanding, educating and inspiring the public, and expanding recreational and cultural resources and opportunities. That act also reflects the General Assembly's recognition that presidential centers are legitimate uses of parkland. The Obama Presidential Center fits squarely within the Museum Act's explicit authorization that municipalities may contract with private entities to build and operate presidential centers in public parks. The city here has contracted with the foundation to build and operate the center, which will, among other things, house a museum telling the story of the Obamas and featuring artifacts and records from Barack Obama's presidency.
Protect Our Parks argues that it is pure fabrication to say that under the use agreement, the city retains ownership of the site. How do you address the argument that this case is like that in Lucas and that a 99-year lease for $10 is not materially distinguishable from an outright transfer of property?
Well, Your Honor, the use agreement in this case, which was attached to plaintiff's complaint and incorporated in there as well by reference, and when we do have a contract that is attached to a complaint, any contrary allegations in the complaint that are contradicted by the contract, in that case it's the contract that controls. So in this case we have, the use agreement has numerous provisions that demonstrate that the city will actually maintain control over the site, unlike in the Lucas case. So we have, the city will retain ownership of the site, will acquire rights to the site improvements, require ownership, title to the buildings and site improvements. The foundation is obligated to operate the site consistent with certain, consistent with as the presidential center, as specified in the use agreement. And there also is numerous requirements for the center to operate in accord with the free admission requirements of the Museum Act, to open the grounds during normal Park District hours, and to operate general admission requirements consistent with other museums and public parks. So all of those features of the use agreement demonstrate that it will be the city that will be maintaining control of the site, and it's not a case where it has ceded full control of the site to the foundation. And regardless of whether we term this as a lease or a use agreement, it is the terms that demonstrate here that the city will retain that control.
Are you arguing that that we really just shouldn't see this as a private use of the land? I mean, that's a big part of Protect Our Parks' argument, that the city has just ceded control as though it was Boeing or the ComEd or somebody who took it over.
Well, the Museum Act does authorize municipalities to contract with private entities. So it's true that the foundation is a private entity that is building and operating the site, but the city is still maintaining control over the site as specified in the use agreement.
And that's because the title goes over to the city as soon as it's built?
So the city retains title to the site itself and will acquire title to the buildings and site improvements upon their completion. And so there's nothing in the Museum Act that indicates that this type of arrangement is improper, and this is precisely the type of arrangement that other museums in public parks, this very type of use agreement with the similar conditions that govern the other types of museums in public parks, which are also operated, constructed and operated and managed and curated by private foundations similar to the Barack Obama Foundation here. And I would also like to...
How do you tie that to the appellant's argument that this contract between the Obama Foundation and the city has been carved off beyond any kind of judicial scrutiny, that it's just out there sort of as its own law unto itself?
Well, with respect to the public trust doctrine, the nature of the contract, we're not looking at the details of the contract. We're really looking to see if it's authorized by the Museum Act itself. And so even under the Museum Act, the General Assembly did authorize 99-year leases, and of course we say in this case it's a use agreement, not a lease, but even if this were a lease, the Museum Act does authorize leases, and under two conditions, that the foundation hold the grounds open during normal Park District hours, and that the city retain a reversionary interest. So those two aspects of the use agreement, we have those conditions here, and we even exceed those conditions here. So and when we're looking at the public trust doctrine, that's all we're concerned about, is whether the Presidential Center was authorized by the Museum Act, and it was, and to the extent this court were to, look to see if this, to decide that this were a lease, and rather than a use agreement, that those conditions would be satisfied. And that's all that matters under public trust doctrine. As far as if there were some, if this court, to the extent this court has concerns about the breach of contract claim that plaintiffs raised in their motion for leave to
Well,
amend.
which they insist is a derivative claim, so maybe you should address that
That's
too.
what you should be addressing.
Right, and my colleague, Ms. Flint, will be prepared to address questions regarding the breach of contract claim, but I will reiterate, as we do say in our brief, that plaintiffs failed to state a claim for breach of contract because they are not third-party beneficiaries and do not otherwise have standing to challenge that, to bring a derivative action or any sort of other taxpayer action.
Ms. Tischer, can I just ask to follow up on one of Judge Wood's questions? The appellants are attacking this as, in essence, a private use. Would you agree that, for example, if what we were dealing with was a contract to set up a use agreement, let's say for a casino or for some lakefront condominiums, that there would be potentially viable public trust claims here?
Well, what we would look at in any case would be what the General Assembly authorized. So if the General Assembly did not authorize, a casino or some other type of use like that on public parkland, then we would be looking at this case a little bit differently under the public trust doctrine, and we would be scrutinizing that to see if it served a valuable public purpose. But that's not the case here. We have a specific authorization within the Museum Act.
And other museums within the park.
That authorizes museums and including presidential centers in public parks. And that is what Pepke tells us here that we are supposed to be looking at here. And Pepke is the case that controls here. And in that case, the court was construing the same 1869 act that created Jackson Park. That case involves Washington Park, but it was the same 1869 act. And the court said that where the General Assembly has created parkland by statute, it is authorized to reallocate that parkland to a new use. And all the court is looking at in those cases is whether there has been a sufficient manifestation of legislative intent. And in this case, we do have that manifestation of legislative intent very clearly to authorize presidential centers in public parks, and that the City of Chicago, municipalities may contract with private entities like the foundation, and that is consistent with how other museums and public parks have operated. And we certainly do not have a private use in this case. I mean, the foundation is a private entity, but it's a use that its primary purpose is to serve the public. And so we have numerous findings. We have findings from the General Assembly itself that museums and presidential centers provide, valuable cultural, educational, and recreational opportunities. I'm sorry, I see my time is up. I would just like to reiterate that we ask this court to affirm the district court's judgment. Thank you.
Thank you. Hello, Ms. Flint.
Morning, Your Honors. Oh, I apologize.
Don't run. Please.
Morning, Your Honors. Tacey Flint on behalf of the Barack Obama Foundation. I'm here to address the court's decision denying leave to amend the complaint to add the breach of contract claim and the unjust enrichment claim. As the court has already raised, there's no right for a stranger to the contract, as the plaintiffs are, to sue on that contract. Now, I did hear Mr. Epstein say at one point, this is not a breach of contract claim, this is a breach of fiduciary duty claim. That is not what is reflected in the proposed amended complaint that the plaintiffs filed. They claimed a breach of the master agreement, which is a contract between the city and the foundation, and they claimed that specifically 2 provisions of that agreement were breached.
But isn't it the case, though, that when we look at a complaint, complaints don't need to plead legal theories? And so if in the facts alleged in the complaint, one can discern some problem of a breach of fiduciary duty, wouldn't that be sufficient?
I don't think so, Your Honor. It's not just that the claim was captioned a breach of contract claim. It is that they cited 2 provisions of the contract and said those provisions were not complied with. So looking at the actual allegations as well as the caption, I don't see any way to read this other than as a breach of contract claim. But regardless, the
So who do you
plaintiffs-
think owed a fiduciary duty to whom, if anyone? The city or the park district or
The
I'm not
General
sure,
Assembly.
The General Assembly. Where's, I mean, you know, like if there's a trust that's set up in plain old private law, you can see who's the settlor, and you can see who's the beneficiary, you can find out the corpus, and you can trace all of this through. But I'm having trouble. I guess the beneficiaries are the public at large. It's kind of an expansive notion of public standing.
Right. There is no fiduciary duty as between the foundation and the city, who are the parties to the contract. Perhaps the theory is that the city is a fiduciary to every taxpayer within the city. That may be where
If
the
that,
plaintiffs.
Well,
if
then
that is the
yeah,
case and
you're in
everybody
trouble.
has standing, it's
Yeah,
a, it's
you're
a,
in trouble.
it's a recipe
Actually,
for
she's not in
judicial,
trouble.
Yeah.
it's a recipe for
Protect
the
our
judiciary to
parties.
govern the city.
I certainly agree with that, Your Honor. And this court has already resolved that such claims are not permissible in the provisions that you cited, Judge Wood, that you quoted from the 2020 opinion, saying that even if under Illinois state law, in that case the court was talking about PEPG, there is a viable claim, there is state law standing to bring a claim for a public trust claim, that still doesn't get you into federal court. Now, none of the cases they've cited have established standing to bring a contract claim in the shoes of the city as if it were a derivative claim.
Or even I mean, you know, to give them their due, you have to analyze this and say, is there just any way you can stretch it into a breach of fiduciary duty or some kind of, I mean, I confess I have trouble envisioning it as a shareholder's derivative, you know, or some form of derivative claim, but that's what they're trying to do.
Right, and I don't think I have not seen any precedent that supports that move. Now, when Your Honor, Judge Hamilton was asking Mr. Epstein about whether there's some kind of business judgment rule if such a claim exists as the taxpayer derivative claim for a breach of contract, Mr. Epstein said no, because this is a strict condition precedent. If what he meant was the city could not waive the conditions that are at issue in the claim, that's incorrect. The contract is explicit in Section 12 of the master agreement in saying that the city may waive those conditions. So even if, contrary to fact, the conditions had not been satisfied, that would not establish a breach of contract. The contract can still be performed and complied with by both parties, even if the conditions were simply not met. However, the proposed amended complaint alleges itself that they were, that the certification required by Section 12H was provided, that the endowment required by Section 12J was established.
But does that mean that you were reading this as just, you know, the paperwork got filed to create the endowment and then you threw $1 million into it and said, done for now? I mean, because there was some magnitude of money that was supposed to go into that endowment to assure performance of later obligations.
Not according to the contract. The contract sets forth conditions that must occur prior to closing, and that is the establishment of an endowment.
Just filing the papers then, not establish in the sense of, you know, create some separate, you know, fund or entity that's going to hold the money that in any amount. You could have put 10 cents in it, it sounds like. and you
Section
would have
12J merely requires the creation of an endowment. Obviously, this is occurring many years before the presidential center will be completed and opened, and the parties expect. Certainly, the plaintiffs have not raised any allegations to suggest that the ongoing construction of the presidential center, which is in full swing, has faced any financial difficulties.
So does the foundation have an estimate about when this is going to be finished?
Yes, 2025 is the estimate.
2025. And, yeah, so the foundation says 2025, and at that point, all of these other use agreements will come into effect.
The use agreement's already in
Yeah.
effect.
Yeah.
Its requirements for the hours of operation of the museum
Yeah,
and so
yeah.
forth will come into effect once the museum is open.
Okay.
Okay, thank you.
Thank you, Your Honors.
Good morning, Mr. Brabender.
Good morning. May it please the court, my name is Alan Brabender. I'm with the U.S. Department of Justice, and I'm here to address the federal claims against the federal defendants. And as this court knows, this court has twice rejected each of the federal claims against the federal defendants in precedential and published opinions.
That's what
during-
I wanted you to talk about. You've briefly raised the argument that even though we understand that the factual predicate at the preliminary injunction stage is often different from what might be there once there's a full record and you're at the permanent injunction stage, there was a stipulation in this case that as I read it, prompted the district court to think that there actually wasn't anything else that needed to be explored. So I would like you to talk about the question whether the preliminary injunction opinion in this instance is dispositive of this permanent injunction appeal.
It is, and it's because of, as you say, the stipulations that were agreed upon below. After this court affirmed the denial of the preliminary injunction, the plaintiffs abandoned all additional proceedings in district court. They agreed to a stipulation that it was proper to enter final judgment at summary judgment based on the preliminary injunction briefing and the administrative
And
record.
presumably the record, yeah, which would include the environmental assessment, I assume from the point of view of the federal, the historical assessments, all these other assessments, right?
That's correct. So this court during the preliminary injunction stage had all the relevant documents it needed to address the federal claims. There's no document before this court now that was not before the court during the preliminary injunction proceedings, which
And
makes
is there
this...
any indication that if the plaintiffs had gotten their amended complaint and things, contrary to the stipulation, I'll comment, but suppose though they'd gotten their amended complaint, are there any facts or lines of inquiry that they have ever raised that they would have pursued?
Not with respect to the federal claims, Your Honor. The same claims are being made now. In fact, it's just a subset of claims being made now on appeal that have been made in the prior proceedings on the preliminary injunction. So the record is the same, the legal issues are the same, and plaintiffs stipulated below that it was proper to enter summary judgment based on the preliminary injunction briefing. So the district court then did enter final judgment based on its preliminary injunction opinion. On these facts, this is the poster child of a case where it is proper to apply law of the case to a situation where there was a ruling made during the preliminary injunction stage.
But you would agree, though, that needs, if we were to agree with you on that point, it would be pretty narrow on this case as opposed to more general concerns about preliminary injunction appeals versus permanent.
Yes, I
injunction
think
appeals.
the law of the case doctrine needs to be applied on a case-by-case basis for every case. It's just so happens that this case is, again, the poster child of a case
Okay.
where the preliminary injunction...
As I understand the federal agency's positions on this, the fulcrum has been, in essence, the site selection was up to local officials here, and we're not second guessing that, basically, right?
That's correct.
And I guess my question is, are there circumstances where U.S. agencies, whether it's highways or Park Service or Fish and Wildlife or whoever, would be in a position to just say no to say, no, we're not going to make any federal dollars available, for example, to move the roads?
Well,
Yeah,
of cour-
and can I just supplement that question? This is concerning me as well, exactly what Judge Hamilton mentioned. If, just for example, the Department of Transportation had said, not a nickel, wouldn't that de facto have been a site veto?
No, it wouldn't. First of all, I think the transportation department has very limited authority, right? If the request meets the statutory criteria, it must grant the funds. But if it didn't, if the request didn't meet the statutory criteria, that does not mean that the foundation couldn't build the center in Jackson Park. They may have to reconfigure the plans a bit, or they could get private funding. They could get funding from the city. So it's not
So
necessarily
your position
true.
is they could build the roads themselves, maybe with state funds, maybe with private money?
Correct.
Yeah, okay.
And I see I have 20 seconds left. Is there any other questions the court has?
Is there anything more you want to tell us in your 16?
No, Your Honor, we would rest on the briefs and the explanations denying the federal claims in this court's prior opinions.
Do you have
Thank you.
anything more, David? No.
Thank you.
Thank you. Okay. No, we're going to give the full 5, please.
I'll need every second. There's a great deal to talk about, but let me first start with the question of whether or not they're standing. Here is a quotation from an Illinois case. It is established that a taxpayer can enjoin the
Which
misuse-
Illinois case, please?
What's the name of the Illinois case, Scott? It's Malik versus City of Belleville.
Okay.
But why is that pertinent to federal standing? The state
Because what
courts, we
happens
know,
is,
can open their
we
doors.
do not need to establish federal standing for this count so long as we have federal standing on others. This-
See, I think you may be mistaken as a matter of law.
This is exactly
on
what happened. No, supplemental jurisdiction. You look at the Michigan case, and what they did is they had federal
that.
jurisdiction
Who's
under federal
they?
statute.
Is this the Supreme Court who did something
No, this
like
was the
that?
district court in Judge Aspen's case.
Yeah, that's
but
what
no, but
concerns
this is beyond dispute. I think this is a Friends of the Courts case where we allege a federal claim. We have supplemental jurisdiction, and
But
so
that's all the same cause of action. You know, there are different theories that you've raised here, and each, as Judge Hamilton said during your first argument, the Supreme Court has been very strict on standing in recent years, and they make it clear that you've got to separately establish standing for damages and for injunctions. You have to separately establish standing for different theories of the case.
I do not think there's a single Supreme Court case which has reversed this decision. Let me finish what it says. Enjoin the misuse of public funds based on a taxpayer's ownership of such funds and their liability to replenish the public treasury for the deficiency caused by their misappropriation thereof when it's illegal. So this answers the question. If you're trying to talk about your snow removal case, there's no allegation whatsoever of illegality, and so it's wholly different from this one where there's a strict condition precedent. The duty of good faith judgment only applies when there's a sphere of action. It does not apply ever when it turns out there's a strict condition. So it turns out the local authority on the state
What
law-
authority do you cite for that proposition?
Well, it's every standard textbook on business judgment rule always says it's a derivative rule when there's a matter of judgment to be decided with their pluses and minuses on both sides.
In a quote, strict condition precedent.
Is not something which is, if,
You lock yourself in to a suicide pact.
No, I did not say that.
If you're the corporate manager.
no, that is incorrect. For 2 reasons. One is that they did have an option which they never exercised, which is when they don't have the funds, they can defer starting date without penalty. They're not locked in on that. Secondly, they could try a waiver argument, which we could then challenge on the grounds that it's insufficient, but they made no waiver argument in this case. They insisted that they complied with both conditions. And that is just incorrect in this case under every standard view of doctrine. Now, let me then turn briefly to the public trust doctrine. The plaintiff's position is incorrect. My defendant's position is incorrect. But they say this is only a matter of legislative intention, and once the Museum Act is clear, all is done. The whole purpose of PEPC was to indicate not only did you have standing, at least in state court, but there was a constitutional action. The final paragraph in this thing says you have discretion within constitutional constraints. The constitutional constraints on this are to make sure that there's not a massive giveaway to a private party, which we have alleged is exactly what takes place in this case. It turns out that the defendants say, well, this is a use agreement. It is not a lease. Well, there's absolutely no term that they cite in this case which was not in the previous lease. And if it's a matter of construction, if you have a document and then relabel it and don't change the terms, this is simply a verbal situation, and it turns out that the 99-year lease has to be subject to this kind of restriction, and they have not done anything to it. They've ignored the constitutional stuff, and they've ignored all the stuff about the particular transaction. On the environmental claims, why do we think that this is not law of the case? Well, what the case that happened in this case was quite extraordinary. The first time this case came up, the decision was we have to examine the question of whether you could locate the Obama Presidential Center in Jackson Park. All the hearings that took place were against that. And then the moment the thing was over, 16 months later, they changed the definition so as to make sure you don't have to consider alternative sites. If they have to consider alternative sites, they're dead in the water.
Who's they, by the way? I mean,
It turns
we're
out
being
the
a little
city
vague.
and the federal
Why,
government.
why did the city of Chicago have any, or under what law did the city of Chicago have an obligation to consider sites other than Jackson
Okay,
Park?
well, I will tell you, this is not the way. The way you put it.
I'm asking that question.
Well, the
if you
answer
can
is,
answer
I'll
it.
answer it. They do not have, the federal government does not have.
I'm not talking about the federal government. What's the law you're pointing to?
The law I am.
That the city of Chicago had to consider Washington Park and, DuPage County or, whatever.
Well,
the Cook County
the
Forest
correct statement
Preserves.
of the rule is, the city can pick what it wants, do what it wants. The federal government cannot order them to consider it.
But you're changing this. I'm
No, I'm
trying
not.
to
I'm
pin
trying
you
to
down.
answer it. The answer is the federal
So
government.
the city of Chicago had no obligation itself to consider an alternative site.
No, that
You
is
think
not
instead
correct.
the federal parties did.
What happens is once the challenge is made under the Environmental Protections Act and under the Clean Air Act, Clean Water Act, whatever the Historical Preservation
I
Act,
saw your
the
things.
duty is the federal government can veto a particular site if it doesn't meet the requirements. It cannot force them to take another site. But the way in which the question is put, that they make the decision themselves and we can't change it, means effectively that every local project that uses federal funds is completely beyond federal review, even when it turns out, if you actually look at the two sites, the site that they have is a disaster. I will just add one point as I'm finishing. The way the district court did it is he made all inferences in favor of the defendant in a case which involved a summary judgment. We have exhaustive evidence that they were completely wrong. There's not a single sentence, not a single syllable in any of the opinions that is written, and on a summary judgment which has looked at the inferences that might be drawn in favor of the non-moving part. And that is just clear error.
All right. I'm breathless. Are you?
No. Standard MO.
He's never worked.
Okay. Thank you very much, Professor Epstein. Thank you very much, everyone at that table. Ms. Tischer, Ms. Flint, Mr. Brabender. Case is going to be taken under advisement. Thank you. Thank you. All right, I think what we will do is we will go on to our second case, and that is Appeal 22-2467, Tabitha Washington and Dante Howard versus the City of Chicago. Hello, Mr. Solon. Good morning.
Thank you, and may it please the court. I'm Patrick Solon. I'm representing the two plaintiffs, Tabitha Washington, Dante Howard, who have claims that they were charged and held in pretrial detention without probable cause on murder charges. For Mr. Edmondson, And probable cause is typically a jury question, and there's work for a jury to do in this case. The police had Edmondson's body, and then there was an autopsy, and so they have a 1-inch hole in his skull, top right, back side, bone fragments into the brain, and a pool of blood behind the dumpster in that parking lot. And in their investigation, the 3 defendant detectives, they gathered actually a consistent body of evidence about the events at the apartment building where the 2 plaintiffs and the 2 others had scuffles with Mr. Edmondson. And the picture from 6 witnesses, 3 at the apartment scene and then the 3 from the parking lot, paints a consistent picture of Tabitha Washington, who's 5'2" to 5'5", according to one of the defendants. Edmondson's big and 6 feet. That she has this little pole, metal pole, and she fends him off, hits the chest, hits the lip. And the 2 men, White and Plaintiff Howard, they have some hands with Mr. Edmondson, and then he walks off. He's on video along the street, the Chicago video, and then he's in the parking lot, walking in the parking lot, and no sign of any hole in the back of his head.
But the video
But the
is not
video is
too
not,
good. Yeah.
Sorry, Your Honor?
the video is
Yeah.
not,
Go ahead.
it's not very clear, is it?
Well, it's not very clear, but it doesn't show a hole. It doesn't explain a hole in the head.
Well, I think the most you can say is it doesn't show him limping along or something like that,
Yeah,
as though
yeah.
he's been grievously injured. He seems to be just walking.
He's
From quite a distance, though, and murky.
he's not in any visible distress, and the hole, once he gets it, has a giant pool of blood. They found no traces of blood along the path, in addition to what's on the video. And one of our primary contentions here is that the evidence available to the police, including these videos, none of it explains the hole in the back of the skull.
So here's what I want you to talk about, because I think it's what this case turns on. This case turns on the difference between the amount of evidence that it takes to constitute probable cause and evidence that would, lead to a conviction. And, in some sense, the system worked for these plaintiffs. They were acquitted. The state judge seemed to have been of a very clear view of what this evidence was like. But at the probable cause level, we know that Washington and Howard are involved in a physical altercation. She does admit hitting him in certain places. People don't necessarily admit everything they did. She admits, we've got Edmondson telling some of his friends that he'd been attacked by the people who lived near him. Maybe that's about the lip, maybe it's about his head, whatever, but they find a metal pole in Washington's apartment, tests positive for his DNA. I'm not saying this is overwhelming evidence, not saying anything like that. I'm just trying to see, why isn't that evidence enough to squeak by probable cause? Because if it is, this case can't go forward. If it's not, then we have a case.
And that was my exact question, because I'd like to add to Judge Wood's question. Aren't most of your challenges more appropriate to establish reasonable doubt rather than to establish no probable cause?
No, I don't agree, Your Honors, but because the 1-inch hole, and the medical examiner at the time, the only one who sees the pole is Detective Alonzo, and he sends it to be tested. And the medical
And that's the
examiner,
one that they find the DNA on.
right? There's a set, and one of them was it. So it's the basket of evidence that they have, right? That determines whether probable cause is appropriate, And so the nature of the pole, Alonzo, he knows that, but the medical examiner thinks it's a pipe. She doesn't see it till the trial, and at the trial, says this little Tabitha would have had to, and it's unlikely she could do it. Now, the two detectives, Valadimas and Garcia, who are interviewing Washington at 3 a.m., they say correctly, you couldn't have done it, this little woman, you couldn't have done it. So what remains unexplained, and this is critical for probable cause, is that she is connected to the cause of death. And that's just a leap of, the probable cause cases distinguish the bare suspicion from the reasonable, and it would have to be an inference here.
Well,
There's no direct evidence.
Can I add and say, and that the cause of death, according to the medical examiner, was consistent with an injury that could have been caused by a pole, by something of that shape and dimension.
Well,
But putting to one side who did that to him, the medical examiner says blunt force trauma to the head. The size of the laceration is consistent with the pipe or whatever it is, pole.
right, and there's a distinction of pipe and pole here. Now, Detective Alonzo, he knows that this is, and it's described by the witnesses who saw it, White and, I'm sorry, I forget the third party, not in the case, as, a light stick, this light thing, not the blunt instrument that the medical examiner is surmising in the autopsy. And again, that all just remains unexplained and requires this big leap of inference. Even at the probable cause standard, there's just no evidence for it.
Well, what about Ms. Washington's statement that Howard hit Edmonston in the back of the head twice with the pole?
Yes, and so that there's no question that the theory they went forward on, they told the ASA, repeated to the bail judges, one of the detectives repeats it in the grand jury, is that it's Washington with the stick. But at 3 a.m., they've got her there, she's diabetic, she's sleeping, they wake her up, they say, you couldn't have done it. Now, they were right. You couldn't have done it. And it had to be White or Howard, the big men that were there. Had to be. And they get her to say it's Howard. They could have gotten her to say it was anybody, probably.
But she does say it's Howard.
Yeah.
She does say it.
In the record.
Right,
yeah.
yes. And so the legal point there, of course, is that for probable cause, it needs to be an objectively reliable. And a jury can find here that it's objectively unreliable, like in the Hurt v. Wise case, where it's not consistent with anything else. They've got six narratives.
In Hurt, the prosecution's theory had a body floating upstream in the Ohio River. We don't have anything quite as implausible here as I see it. And what we see is police have a body, and they have a lot of confusion in conflicting statements and have a hard time figuring out whom to believe about which details, what may be still being concealed. But they know they've got that altercation, and they've got Washington saying that Howard hit him in the head. I have trouble seeing why that's not enough.
That Howard hit him in the head? Well, they knew that was inconsistent with everything else.
Why? I don't know why you say that.
Yeah.
I mean, she's maybe this makes her an accomplice. Who knows? But the two of them are involved in this altercation. Maybe, for all we know, an undisclosed detail. Howard grabs the pipe from her and jams it into his head or something.
Well, but nobody said that. And in fact, people said the opposite, that it was Washington who had it.
For a while. I mean, but, not like glued to her fingers. I mean, because she has it, that gets it there into the altercation. Probable cause is just, do we have enough to go forward on? That's why I say I think the essence of this is, is this so far below, or maybe a jury question, as you've argued, on probable cause? Or is it something that the facts that we know about are enough to clear that barrier.
And our contention is, of course, that it is a jury question. I
Right.
mean, we're not seeking matter of law. And the proper inferences from that basket of evidence was the Washington 3 a.m. Statement, which she, explained was wrong and didn't match anything else. And Washington herself being able to do it, none of that explains that big hole in the back of the head. And what they should have done here is just continue to investigate.
How do we factor in the fact that Howard had lied about his identity to the officers? Washington had lied as well in order to protect the identification of Howard.
None of that weighs on the actual being the cause of the murder. And the Curry v. Chicago opinion
Well, but it
addresses that.
certainly would go to, probable cause, wouldn't it?
Well, the Curry opinion refers to, well, it shows that they have something to hide. But it's not probative of, having committed a very specific crime they're being accused of here. It's not general probable cause. Is it a bad guy? We should, she's accused of causing the hole in the back of the head and nothing more. And the alternate theory that no one pursued, that Howard did it, would be the same thing, that he
Mr. Sullivan,
used this pole.
if I could ask you, you have mentioned a couple of times the detective's statement to Washington, in essence, we know you couldn't have done it. I look at that and it seems perfectly obvious to me it's a manipulative interrogation technique. Are you saying that that should be treated as, in essence, an evidentiary admission, and they should be held to that for the truth of statements they make to a suspect in an investigation?
Our contention is that's something the jury should weigh here. The jury should weigh it here. The detectives have not testified that, oh, no, we deliberately lied. We're telling the truth now. We lied then. The Supreme Court says we can lie to suspects, and so that's why we did it. It's objectively a reliable statement by the detectives that she couldn't have done it. I mean, she's this little woman, and with this pole that is not the pipe that
Who's to say that Mr. Edmondson never fell or was on his knees or anything like that? I mean, the detectives are facing a mystery here. What do you think happened to Mr. Edmondson?
Well, that he hit the dumpster. I mean, that's the one, and without the probable cause that it had happened a half hour before and a half mile away, and he's showing no signs of the hole
Anybody
in the
test
head.
the dumpster for blood?
Not that we saw on the record.
Yeah.
That's the additional investigation that they should have done.
Height
And
of-
it's
the
their
height
job,
of-
right? Not mine.
The height of the dumpster.
And because he only appears in the pool of blood with the big hole in the back of his skull when he's behind that dumpster. There's nothing before then. And it's the basket of evidence. Yes, there's other evidence that they didn't have, but that doesn't supply the probable cause. The question is, the reasonable inference, whether a reasonably prudent officer jumps to that conclusion. And a jury could find here that they didn't have enough to make that very specific conclusion as to either Washington or Howard, based solely on that 3 a.m. episode. All right. And beyond that, it's there is the second element that's ultimately proximate cause. And after Manuel, we have the Fourth Amendment case surviving yes, there were bail hearings, you have transcripts, the grand jury, there's a transcript. None of those finders of probable cause had the full picture, and so it survives that.
Thank you.
Thank you.
Mr. Collins. Good morning.
May it please the court. Plaintiff's violent encounter with Mr. Edmondson, minutes before he died, gave the investigating detectives probable cause to believe that plaintiffs inflicted Mr. Edmondson's fatal head wound.
So here's what worries me about the probable cause finding. I mean, it's a very close case, it seems. Certainly there was the encounter. The evidence from the encounter seems to be exclusively to the front of the face. Now, I realize your head includes both the back of your head and the front of your head. So if you say it's to the head, it means the lips. It doesn't, that's not lie or anything. But it certainly doesn't indicate anything about the back of the head. So that bothers me. And even more, not that it's the greatest video in the world, but if somebody had the kind of injury that was discovered on the remains of Mr. Edmondson behind the dumpster, I just can't see that that would be the gait and the way that they would walk from the first place to the second place. It just doesn't make any sense. It's maybe not Scott versus Harris level of video, but it's, you don't see, maybe I'm just making a lay assumption, but a giant hole in the back of your head where you've got skull fragments inside the brain and you're bleeding profusely just doesn't seem to be the same person as the one who was walking down the street captured on the various videos.
As to the first part of your question about the specific blows, it's true that there was not evidence in the form of an admission by Ms. Washington or Mr. Howard, or by...
Well, you got to get him around to the other side of the head, because otherwise somebody could have snuck up on him behind the dumpster when he was out there. I have trouble imagining that he fell into the dumpster like that too, but there are plenty of explanations, and he winds up dead. So that's.
But in the course of a fight, Mr. Edmondson could have bent over, been on the ground, and sustained the fatal injury at the hands of plaintiffs.
Yes, but
in that way.
you see, he could have, he might have, he probably
And you still have
did.
the walk afterwards. That's my trouble with that.
Sure.
I'm with you as far as thinking that it was a chaotic situation with Ms. Washington and Mr. Howard fending him off, and apparently he was hyped up on all sorts of things, so he was probably irrational. But if he really sustained the fatal injury at that moment, I don't see how you get him walking in the way that the video captures.
Well, of course, when it comes to viewing the video, the detectives do not have to have the medical knowledge to know for certain one way or another what would have been possible after sustaining a potentially fatal head injury. The question is whether their inference is simply reasonable. But beyond that, if there is any question about medical possibilities, the coroner in this case testified that yes, it would have in fact been possible for Mr. Edmondson to have sustained a fatal injury at the location of the fight and then walked the distance he
I
did.
don't think they said at the location of the fight. I think they just said it was consistent with an injury that could be caused by a pole.
At the coroner's deposition, she was asked whether it would have been possible for for Mr. Edmondson to walk the distance that he did, which I believe was about a half mile before ultimately dying, and she testified that yes, that would have been possible. So if there's, to the extent there's any question about medical possibilities in this case, the evidence supports the detective's inference. Now,
And nobody ever checks for blood along the path. It seems like to walk a half a mile without bleeding a drop of blood seems counterintuitive.
Well, the witnesses who saw Mr. Edmondson in the parking lot immediately before he passed away saw that he was in fact bleeding from the face and
From his lip, not
Right.
from the back of his
Not,
head.
not from the back of the head.
Right, and they didn't, in that interaction, they didn't have the opportunity to see the back of Mr. Edmondson's head because they were talking to him face on.
But the back of the head is a very vascular area. I mean, you wouldn't miss it if somebody had a giant, wound there.
Well, it was dark at the time of the interaction, and blood, of course, is dark. So I believe it's altogether possible that that could have been missed in the course of that interaction. Ultimately,
What was the, would you say that the criminal liability of Ms. Washington and Mr. Howard is dependent on whether Edmondson received a head injury during their altercation with him.
For criminal liability, yes, it could, because they were, of course, charged with murder and felony murder. So, yes, for them to have been guilty of those charges, Mr. Edmondson would have had to sustain the fatal injury during that fight. And
In other words, if the fatal head injury was caused by the fall, okay, could they still have faced criminal liability if the injuries from the beating were the reason that he then lost consciousness and fell?
I don't know if that would support a first-degree murder charge, Your Honor, and I don't believe that's the theory that the prosecutors move forward with in this case. But presumably, my intuition is that that theory would support some form of criminal liability in this case. But I do want to emphasize here that we're dealing with the probable cause standard, of course, and not proof beyond a reasonable doubt.
Of course.
And the facts that the undisputed facts that the detectives uncovered in the course of their investigation satisfy the probable cause standard, because there was the fight. There was the fact that Ms. Washington admitted striking Mr. Edmondson several times with a pole, including a blow to the face. The blows were forceful enough that the pole ended up with Mr. Edmondson's DNA on it.
So can I just ask you, there's sort of a thread of this in this case. I don't hear you relying on the notion that there was at least probable cause to arrest them for just the battery, for a lesser crime than murder.
Yeah.
Are you agreeing that it had to be probable cause for murder?
For purposes, well, so the court has not decided whether probable cause for some hypothetical charge defeats a Manuel claim such as this. We don't think there's need to decide that issue in this case because there was probable cause to support the murder charges. Also, I note that for purposes of the state law malicious prosecution claims, we know that probable cause for that claim is charge specific. So defendants would have to establish probable cause for murder to defeat the state law malicious prosecution claim.
And presumably, a pretrial detention versus bail decision would look very different if it were just battery.
I presume so as well, Your Honor. Obviously, we don't have the record establishing that, but that would be my assumption as well. And as an additional fact that supports probable cause is that Ms. Washington several times told detectives that Mr. Howard was the one specifically who struck the fatal blow to the top of Mr. Edmondson's head.
Is that the only evidence they had to that effect?
It was the only evidence that made Mr. Howard responsible for the blow to Mr. Edmondson's head, and it was the only, I suppose it was the only admission by or evidence offered by either of the plaintiffs that constituted a statement that either of the two plaintiffs specifically struck the fatal blow.
So what do we do with this evidence that the detectives told Washington you couldn't have done it?
Your Honor, I think you correctly intuited or sensed.
Why isn't that a jury question?
Well, for a few reasons. One, I think the most reasonable, by far the most reasonable reading of that question is that was an interview technique to try to get more information.
But as you're answering this question, please also address the underlying fact. Apparently, I haven't seen her, but Ms. Washington is a petite person, and for her to, with sufficient force to inflict that harm, I'm not saying it's impossible, but it's less likely.
Well, Your Honor, the implement that was used was a metal pole that the coroner opined was consistent with the fatal injury. But to go back to the 3 a.m. Questioning of Ms. Washington, even accepting that the detective's statement we know you could not have done this, accurately and sincerely reflects their belief at the time. Probable cause is an objective standard, and so the detective's subjective belief at that time would be irrelevant to the probable cause question. And on top of that, the detectives could very well have changed their mind in the course of the investigation. The investigation was not over at 3 a.m. It continued after that, and a reasonable detective can change their mind as more evidence comes into the case. But apart from probable cause, there's an independent basis for affirmance, which is that the detectives did not cause the pretrial detention or the prosecution. Prosecutors, rather than the detectives, brought the murder charges against plaintiffs.
So plaintiff's argument is that the detectives presented the prosecutors, though, with untrue or misleading information. And if that is true, that would break the chain that you're suggesting exists.
It would break the chain only if the supposedly falsified or fabricated evidence was material to probable
Well, but
cause.
that's certainly their argument. That
Sure, yeah. And they rely principally on this felony minutes form, which is a one-page document that the detectives filled out that said that the investigation learned that Ms. Washington struck Mr. Edmondson on and about the head several times with a metal object.
But of course, as I said earlier, hitting you in the nose or the mouth
Right,
is
it's
quite
not-
different from creating a
Big hole.
inch-and-a-half hole in the back of your skull.
Sure, yeah, certainly those are different specific blows, but the fact that there were...
And less likely to be fatal. A split lip isn't fun, but it's not likely to be
course.
fatal.
Of course, but the fact that there was an admitted blow to the face supports an inference that in the course of the same fight, there was also a blow to the back
Why
of the
does
head.
it support that inference?
Because it's physically close, it's the same part of the body.
Well,
and
but-
it would be a different case if the
I
only...
mean, the pole didn't go through his forehead.
No, it did not. But the evidence would be different if, say, if the only admitted blows were to Mr. Edmondson's kneecaps or
I don't see
lower
why that's
down.
true at all. I mean, you're in the
No.
middle of a fight and you flailing around so you could hit anything. I mean, it sounds like, if you so much as pinch somebody, then maybe you murdered them too because you were in a fight with them.
Oh, dear.
Well, I submit that the evidence supporting the reasonableness of the detective's conclusion here is much stronger than that, because we do have an admitted fight, we have an implement that was consistent with the fatal injury, and that was enough to support the probable cause standard. If I may speak a bit more about causation, it was the prosecutors who brought the murder charges. Prosecutors brought those charges only after conducting their own independent investigation of the case. They presented the charges to judges and a grand jury, all of whom found probable cause. And the detectives did nothing to taint those pretrial proceedings, nor did they engage in any wrongful
Is
conduct.
that an undisputed characterization of this record?
I think
Looks
it
like
is.
it is disputed.
Yeah, we might ask Mr. Solon.
Sure. Well, with respect to the felony minutes form, it did not state any fabricated evidence. This might be a different case, for example, if the form stated that Ms. Washington confessed or admitted to having struck Mr. Edmondson on the top of the head. The form did not say that. And even on the theory
Or
that...
she recanted.
Right. Well, she didn't. She at no point during the investigation did she personally admit that she struck Mr. Edmondson with a pole. She only identified Mr. Howard as that person. But even on the theory that the form does state falsified evidence, Manuel still requires that the fabricated evidence be material to probable cause. And the court may ignore the form altogether, take it out of the case entirely, and probable cause nevertheless exists. Briefly, I see my time is almost up. I'd like to address qualified immunity. At a minimum on the Fourth Amendment claims, the defendants are entitled to qualified immunity for a couple of reasons. One is that plaintiffs have identified no case clearly establishing that facts similar to these do not give rise to probable cause. nor do they cite a case showing that investigatory conduct akin to what the detectives engaged in here amounts to a Fourth Amendment violation. So for these reasons, we ask that the district court's judgment be affirmed.
Thank you so much, Mr. Collins. Thank you. Mr. Solon, you used up your time, but I will give you 3 minutes, please.
Oh, yeah, I didn't realize we used the full 15.
Yeah, you did. I didn't want to interrupt and warn you, but I should have.
Well, we were having a good time.
Okay.
Briefly then, so I don't take more time than needed.
Mr. Solon needs a life. Go ahead. Go ahead.
On causation. So there are many disputed facts there. It's not just the false narrative in the Clear Clothes report. The state's attorneys went to the bail judges and repeated the overheard incriminating statements as a key part of the narrative. And that's just a lie, or so a jury can find when we try the case. And the videos were not used. The poll is at the state lab, and it's the defendant's filtered narrative that gets looked at. Not until the criminal trial does anyone see the real basket of evidence that was available at the time, but known only to the detectives. On the issue with the medical examiner and the state of Edmondson, the 3 parking lot witnesses are key here because they're not implicated in any way. They see him, they get a good look at him, and Khadijah Hill says 10 minutes. I'm talking to him. They note that he's got what they describe as minor, and he turns around, he walks away. There's no gaping hole. And the medical examiner...
So you're drawing the inference she would have mentioned a gaping hole in the back of his head had there been one.
Yes. And there's no inference that there was one from her not saying it. And the medical examiner says there would be a lot of blood. There was a lot of blood down there behind the dumpster,
yeah.
right? And there would be a trail. There was no trail. And that once she looks at the poll at the criminal trial, you'd have to drive it perpendicular, and it's unlikely, her words, unlikely that you could use this weapon, which she sees for the first time, to have done this. So, we request reversal and remand for trial.
Thank you very much, Mr. Solon. Thank you very much, Mr. Collins. Case will be taken under advisement, and the court is going to take a 10 This is case number 222364. Hi, Mr. Stevenson. How are you?
Doing well. How about yourself? Good morning, Your Honors. May it please the Court, Adam Stevenson on behalf of Appellant Bryant Aaron. Mr. Aaron has two primary sets of issues on appeal, but I'd like to begin today and focus on issues relating to the 11C1C agreement that he entered into with the government. That agreement for 96 months was, in our position, accepted then rejected, or at least rejected inappropriately, and then resulted in him going to trial and receiving a statutory maximum 120-month sentence. The one difference between the 96-month sentence and the guidelines that played in there and the guidelines that ended up post-trial was the acceptance of responsibility credit, again, leading to that much higher statutory maximum sentence. And at threshold, or at the beginning, there is this question of whether the district court accepted then rejected the agreement. And this is important both because Brown from this court instructs us that ambiguities are relating to acceptance resolved in the defendant's favor, and Ritzema indicates Rule 11 requires a district court to give a definite announcement of acceptance, rejection, or deferral.
So
now-
let's look at page 7 of your brief, where you've set out precisely what the district court said. It's not clear to me that the district court has done anything more than accepted the recommendation. So that's the predicate of this. The magistrate judge recommends the court accept defendant's plea of guilty and adjudge the defendant guilty. So the district court says she adopts the findings and recommendation and the recommended disposition. I read that as the plea of guilty. And then she goes on to say, subject to this court's consideration of the plea agreement pursuant to 11C. So I see her, sort of dividing this into two things. One, acceptance of the plea of guilty, and two, acceptance of the 11C1C sentence. And that's where she, after looking at the relevant materials, she doesn't think that's adequate for this offense, and then he's allowed to withdraw his guilty plea, gets, in a sense, his full due process rights.
So with regard to the second point, or the second component of document 55, the court's written order accepting the recommendation, we would disagree for a couple of points. One is, subject to the court's consideration of the plea agreement pursuant to Federal Rule of Criminal Procedure 11C, if applicable and necessary. And Federal Rule of Criminal Procedure 11C covers several subsections. It does include 11C1C and the consideration thereof, but a number of other plea agreements and types of judicial consideration. And so it is at best ambiguous, and again, with that caveated language of if applicable and necessary, where at no point prior and no point immediately subsequent does the district court clearly indicate that it is still considering the plea agreement as it needed to under Ritzema. Again, that clear statement.
But she says subject to further consideration, I'll just summarize, the plea of guilty to the offense is accepted, and he's adjudged guilty, but she doesn't say anything about the length of the sentence.
And nobody at sentencing seems to have been confused about this, since counsel were making arguments to the court as to why the plea agreement should be accepted.
So I think with regard to the statements of the parties at what was called and was held as initially a sentencing hearing, both the parties, to Judge Hamilton, your question, both parties indicated that they were making objections, but that they didn't matter, that the binding plea...
That's not my point. Not about objections to guideline issues, but they were making arguments as to why the plea agreement should be accepted.
Yes, eventually the sentencing hearing did transition into approximately 11 or 12 pages within the transcript, transition into, at the district court statement, a consideration of the plea agreement. But again, against the backdrop of Brown and the ambiguity of acceptance being ambiguity being resolved in the favor of acceptance.
What's ambiguous about subject to language that the district court used?
There are the 2 points. The 11C doesn't provide sufficient notice that this is, in fact, the consideration and the type of plea that is being considered. And the if necessary and appropriate language, or if necessary and proper language, reads as if it is a standard or boilerplate language that's filed with this type of adoption or recommendation. This is contrary to...
What's wrong with boilerplate language to deal with a routine kind of procedure?
I think there's nothing wrong with boilerplate language generally. However, I think what would have been appropriate and would have in some ways resolved the matter would be to clearly indicate, subject to the consideration of an 11C1C agreement, the one agreement that would bind the court. And again, 11C contains a number of other components to it that doesn't give sufficient notice to counsel with regard to acceptance or rejection. But to the point of if the court feels that it was not accepted and then rejected, there are a number of matters with regard to the district court's rejection of the agreement that were also inappropriate. First of all, the district court improperly participated in the plea negotiations in violation of Rule 11 through two particular types of comments at sentencing. First, with regard to questions made and statements made about the propriety of a plea in this type of case. The court directly asked the government why seek a binding plea, why a plea in this case, instead of just giving the acceptance of responsibility credit up to the 3-point level. Second, in similar circumstances to that of Crowell in the Fifth Circuit, the district court said numerous times that a much more significant sentence would be necessary, that there were far more aggravators than mitigators. And this is contrary to what the lead opinion in O'Neill says of to run shy of participation, a court must simply provide reasons for rejecting a plea without much editorial comment.
Okay, you know the question that's coming, right?
Right.
Which is, do you think the district court said too much or too little? By way of explanation?
And I think the answer is yes. Too much about what it shouldn't say, too little about what it needed to say. So with regard to Your Honor's question, too much with regard to the editorial comment. Again, the questioning with regard to the propriety of the plea itself. That gets into the sort of blatant and or subtle pressures of the judiciary, which Krauss says that's the concern of a participation claim.
Well,
yeah.
most district judges are not wild about 11C1C pleas. That some at least pushback is not surprising to me. Is it inappropriate?
I think where it rises to the level of editorial comment, I think yes. I think it does weigh into future negotiations. It weighs into what may come to follow or whether such an agreement may exist in a given case within that single case.
But why does all this matter? Once the district judge resets the clock, basically, and says, we're not going to have a plea agreement, you're going to go to trial, it's going to be, now that's true, he loses acceptance of responsibility, but that's something that happens if somebody goes to trial sometimes. And, you know, the judge makes it clear why she thinks the 120-month sentence is the appropriate one. I don't see how the ultimate result in this case is really influenced by what you're talking about.
Specifically with regard to the participation.
Yeah, but with regard to the participation, I mean, she may be musing about, gee, I don't know why that happened, but by the time she puts it back, you know, at the beginning and says we're going to move forward with the trial, those are the rights that in these Rule 11 colloquies, the judges are telling the person you're losing if you take the plea. You're losing the right to a jury of your peers. You're losing the right to confront witnesses, blah, blah, blah. You lose all these rights. So, in the end, he has a trial. Isn't that the process that he's due?
No, Your Honor, I don't feel that is the appropriate process that's due. And this is a case in which the guidelines and the statutory maximum and the interplay of them, I think, adds additional complexity. That is, again, the only moving piece of the guidelines here was the acceptance of responsibility credit. Within the agreement was 2 points. The government did not choose to move for a third point because of the binding plea. Then, after the trial, the 3-point addition or the failure to provide it led to the statutory maximum becoming the guidelines range. In a different matter where the sentencing range was much larger, it might be a different case. But here the prejudice was direct and clear, given the district court's comments in sentencing. Speaking of, with regard to rejection, this is where the district court said not enough, but also did say too much. Not enough with regard to specifically identifying those matters under 3553A as uniquely tailored to Mr. Aaron that would be sufficient to reject a guilty plea.
Gosh, I thought that she quite clearly explained the Section 3553 factors.
So with regard
Why
to
am I wrong?
Your Honor, you're wrong on 2 points. One is the district court makes rote statements about considering certain 3553 factors, and analogizing to sentencing, Starko, among others, indicates this is not often enough, just simply stating or indicating certain factors are at play. In addition, the district court notes a concern about unwarranted sentencing disparities. There was no co-defendant in this case, so the unwarranted disparities would be those of other folks with felon in possession of a firearm cases, which the guidelines themselves, as this court said in Matthews, take account for. And so by rejecting...
No, I don't see the disparities pointed all that way. You know, we've said you can look at disparities between co-defendants if there happens to be one, but in general, disparities are a larger inquiry. Yes, the guidelines take you part of the way, but people certainly make disparity arguments.
Mr. Stevenson, let me ask you, your answer to my question was yes, about too much and too little.
Yes.
How would you write an opinion articulating in a way that a district court judge could read and understand and then follow to say enough but not too much?
Yes, Your Honor. First of all, at an initial matter with regard to the editorial comment, that is inappropriate for the participation claim. With regard to the acceptance and rejection...
And
editorial,
making sure the judge knows what counts as an editorial comment.
as opposed to a reason for rejecting as an inadequate sentence.
Yes, and this is the exact issue that Judge Posner raised in the concurrence in O'Neill. That is that this is the judicial equivalent of squaring a circle. It is specific 3553 factors and specific connections and information about that defendant.
How is that not negotiation then?
So with regard to the appropriateness of the sentence under 11C1C and the potential alternative sentence or fit within the guidelines range, especially because the guidelines contain policy statements about the guilty plea acceptance process, it is a requirement that a district court provide more and specific information under 3553A in order to reject. But again, not going so far, which is a very fine line.
Well, okay. You're creating a razor's edge, and I'm asking you to articulate a rule that a district judge could follow.
Yes. The rule I would suggest is that consideration under 3553A and the specific facts or information about that case that demonstrates that that area is a concern. Similar to that sentence.
What does that mean?
That, for example, unwarranted disparities because this case is of a unique type that needs greater than other particular felon in possession of a firearm.
But she did that with the 3553.
This criminal history is not adequately reflected by the guideline calculation.
So those, with regard to those matters and considerations under the guidelines, we discussed with regard to Coda Luna in the, it's now escaping me, Coda Luna in the Sixth Circuit with regard to considering and basing rejection on the guidelines themselves is also potentially problematic, I guess, especially against the backdrop. The district
judge doesn't have to follow them, so, right?
Correct, but the guidelines themselves as a policy statement in 6B1.2C indicate that sentences within the guidelines are one of the plea agreements that the court should, not required, but should accept. And that, again, the concern being in a case like this with a statutory maximum very close to what was the agreed upon sentence, there is a significant danger of prejudice through inadequate notice about the preservation or reservation of right to consider a plea, and then the insufficient rejection or inappropriate rejection. I see that my time is concluding. I'd like to reserve the remainder for rebuttal. Thank you.
Thank you.
Good morning, Your Honors, and may it please the court. The district court had the power to reject Aaron's C1C plea agreement, and it acted within its discretion in electing to do so, and the court should therefore affirm. Turning first, Your Honor, to the claim that the district court had no power to reject the plea agreement, the court never accepted the plea agreement. Nothing in Appendix 3 suggests that the court did accept the plea agreement. It referred the question of accepting the guilty plea to the magistrate. It received a recommendation, and it accepted the guilty plea, and it did so subject to this court's consideration of the plea agreement. That suggests to me that the court had not yet accepted the plea agreement. The only way I think to make sense of that language, that it was accepting it subject to Rule 11C, is that the one part of Rule 11C that deals with the guilty plea is Rule 11C 5B, which says if the court later decides to reject the plea agreement, it has to give the defendant the opportunity to withdraw his guilty plea. And that's what happened here.
Mr. Holler, can I ask you a couple of questions about practice in the Northern District of Indiana?
Yes.
Is it routine for pleas to be taken by magistrate judges?
It is judge specific, but
Okay.
with some, yes.
Okay, it depends on the division and the judge. Okay.
In the Fort Wayne division, I would say it is generally the practice that the magistrate accepts.
Okay.
Yes.
And is there you might know, you might not want to tell me, and I respect that, but is there a history involving 11C1C pleas with Judge Brady or with other judges in the district who push back against them routinely, or I don't know how often they're used. So
they aren't regularly used, but they have been used on occasion. I believe Judge Brady has accepted C1Cs. I believe this was the second one that she rejected. It was not the first.
Okay.
We don't routinely use them, I would say. And in this instance, as my brief explains, we did initially offer a pretty standard C1B plea agreement. It went to the magistrate, and the defendant at the last minute got cold feet and said he wanted a C1C or nothing, essentially. So that's why we tried the C1C here. So the court did not accept excuse me, Your Honors. The court did not accept the plea agreement. On the question of what
So the critical distinction here, which I think does exist in the law, is that between accepting the plea and accepting the agreement.
Absolutely.
Right.
And the court accepted the plea subject to its consideration of the plea agreement. So it's Hyde, essentially. I think in terms of the question of whether the court improperly participated in plea negotiations, that is controlled by Krauss. We're not writing on a blank slate and trying to come up with law. I don't think the court can say it any better than it already said it in Krauss. The court can make, within reason, whatever comments it needs to explain why it's rejecting the plea agreement. It cannot comment on hypothetical plea agreements, on future plea agreements. It can't say, I'll never accept a C1C. It can't say any of those things. But here, I mean, my opponents divided this, I think, into two baskets. One, essentially, are the court's explanation of why it's rejecting the plea agreement. Krauss says that's fine. And in fact, in Krauss, the court says a whole lot more than it says here. And the court was clear that although that was very close to the line, it didn't really recommend doing that, that was okay. The problem was then the court went on, and in fact, in that case, it was the staff, but in Reitzma, it was the court, who commented on, well, we would accept 151 months or whatever they would accept. And you can't do that in any way. The court never said, I'll only accept 120 months here. It didn't say that.
I mean, it was indicating perhaps that just 96 didn't seem like the right number.
Right. I mean, the guideline range here was 100 to 120. Maybe it would have accepted 100. Maybe it would have accepted 110. I don't know. And we don't know because the district court never said, and the defendant didn't go on as it could have to say, all right, let's go ahead and plead and let's see what the district court says. And if the court's comments at that point were insufficient, then he could have raised a procedural or substantive reasonableness claim. He chose instead to exercise his due process rights. So I think Krauss controls on that issue. On the question of did the district court say enough, the court said more than enough here. And I think the key case there is Viren, where the court said almost nothing. I mean, the court basically just said, I don't think this is consistent with the 3553 factors. And the court said well more than that here. In fact, all the court said in Viren was, I'm unwilling to accept the sentencing limit as agreed to by the parties, period. Well, if that's enough, then the page or so that Judge Brady went on to here that pretty much, I think, explains that it's his criminal history that is 20 points, far more than the 13 he needs for criminal history category 6, that suggests that this sentence is not enough for the court. And it's significant criminal history.
Mr. Hogg, where an indictment fails to require knowledge of a defendant's status as a felon, would the submission of the proper elements to a jury and a jury's finding of guilt prevent any successful challenge to the indictment as a matter of course?
Well, I don't know that it always would, but what the court said in Cotton was that if the evidence is essentially overwhelming and uncontroverted on that element, then we're not going to find harm here. I mean, first of all, we don't think that there was error, let alone plain error, in the indictment. But if the court thinks that there was, then this case essentially is identical to Maez, where there were, in fact, it's better than Maez. In Maez, there were arguably errors both in the indictment and in the instructions to the trial jury. Here, the correct instructions were given to the trial jury, and the defendant stipulated on that point. So I think in light of Cotton, which says there's not automatic reversal for an error in the elements presented to the grand jury, to the extent that the court thinks there was error in the elements presented here, the court could not find plain error.
This indictment just tracks the language of the statute, though, right?
I believe it basically tracks the language of the statute, yes. The
So
problem,
it's a Rahafe error, right? It's a Rahafe error.
the argument is there's a Rahafe error, but the language here, unlike in the Batiste case, which was part of Maez, where knowingly was sort of stuck in the middle, right? It sort of said, I mean, in Maez, it said the defendant knowingly, yada, 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 everything. And the court said, well, you could read that to apply to both the felon status and to the possession status. In Batiste, it was the defendant being a felon knowingly possessed a firearm. And the court said, well, you can't reasonably construe knowingly back here. So this one now, we now have the defendant being a felon and possessing a firearm and did so knowingly. So I would say this is like Maez, you read it back to both. Now in Maez, there was trial error, so the court still had to reach the issue. My argument here would be there's no error. Certainly there's no error. I don't think, unlike in Maez, the defendant has demonstrated good cause. The burden's on the defendant if the defendant thinks he doesn't understand the indictment to go forward and to say, I have a Rule 12 objection. Now that was excused in Maez because this court had case law saying, we're not going there.
Well, it was an intervening Supreme Court decision.
Well, the case was on appeal.
Yes, exactly.
Well, here the intervening decision came down the day after the grand jury indictment was returned. The defendant had plenty of time to file a Rule 12 objection. So I don't think there's good cause here to even reach the issue. But if the court wants to get into the merits, as Judge Rovner asked, at that point, I think this follows from Maez, this follows from Nance, this follows from Cotton, that the evidence here was overwhelming and uncontroverted. Could the defendant have made this an issue at trial? I suppose he didn't. Could anybody have made this an issue in the grand jury, that there is probable cause to think that the defendant, who twice spent more than a year in jail on a felony, might have known that he was a felon? No, there's probable cause to think he might know that. That's the standard. So if we didn't present this to the grand jury, and there's no evidence of that in the record, the grand jury surely would have said, yeah, we think there's a reason to think he might have done that. So I think it would be a very rare and unusual set of facts where, after the defendant was convicted at trial, he could raise a claim like this on an element at the grand jury stage. But I think the court can reserve that if it wishes to. My opponent did not discuss the guideline issue. I don't think there is a guideline issue here. For all the reasons we've already expressed, the court did not accept the plea agreement, so anything related to that doesn't show anything. And the court did not clearly err here. The cases that my opponent cites involve instances where the defense at the sentencing hearing raised factual objections, so the government had to come in with facts. Here, Judge Brady asked at the status hearing, do you want an evidentiary hearing? Are you challenging the facts, or are you essentially just raising this acquitted, non-convicted conduct issue, which is certainly, a hot button issue right now, and it's fine for the defendant to preserve that issue. But that appears to have been the only issue the defendant was preserving. He's not particularly raising that here, and so there was no need for us to have an evidentiary hearing based on the undisputed facts in the pre-sentence report. The district court did not clearly err in finding that he used the gun that was found in his car to shoot this man 9 days earlier. If the court has any more questions, I'm happy to answer them. Otherwise, we would ask that the judgment be affirmed.
It's not.
Thank
Thank
you.
you very much. Mr. Stevenson, give him his full 3 minutes, please.
Thank you, Your Honor. Just 3 points today in rebuttal. First, with regard to the reference in Kraus, King, and Viren, are all cases that do set out when rejection of an 11C is appropriate. Specifically, though, with regard to Viren, the court's opinion does give short page length to what the district court said at sentencing, but looking to the government's briefs and the actual citations to quotes of what the district court said in those briefs, it was much more extensive. In fact, the district court indicating that it was one of the highest reoffense risks for a defendant that they had ever encountered. So it wasn't just a simple statement of, I don't feel this is an appropriate sentence. With regard to the indictment matter, Judge Rovner, and your question about the jury instructions and other matters, Wabanese and Manuziak from the Third Circuit in our brief indicate that even completed jury verdicts pursuant to correct indictments are not correct instructions are not necessarily sufficient to overcome this violation of the Fifth Amendment right to sufficient indictment. And then last but not least, with regard to Mayes features two different defendants in that case with different indictments that I think are relevant to Mr. Aaron's case. In Mayes, the knowing phrase preceded the prior conviction stage, so it does seem to follow more naturally. However, the defendant Baptiste had knowing after the prior conviction phrase, and therefore the court did not feel that knowing could be read appropriately in reverse. In Mr. Aaron's case, knowingly is at the very end of the indictment, and therefore, I think similar to Baptiste, if not perhaps even more so, makes it an odd construction to read knowingly consistent with everything that preceded it after having read through the entirety of the indictment. Therefore, Mr. Aaron does feel that this is plain error. Unless there are remaining questions, Mr. Aaron asks the court to vacate his conviction and sentence and remand for further proceedings.
Thank you so much, Mr. Stevenson. And Mr. Stevenson, you were appointed, were you not?
I was.
You really have the court's gratitude
Thank you.
for the fine job that you and your associate
Thank you.
have done. And Mr. Holler, thank you for the fine work you do for the government. It's really a pleasure to have you both, all three of you. All right. The case, of course, as always, is going to be taken under advisement. I'm going to call case number 4, and that case is United States versus Hibbett. Hi, Mr. Hillis.
Oh, Judge Rovner, nice to see you
So nice to see you.
and your colleagues.
With a beard, no less. I'm not allowed to do that.
That's just till my wife says to shave, which will be when I see her tonight. But may it please the court, counsel. My name's Daniel Hillis. I'm with the Federal Public Defender's Office. I represent Mr. Hibbett. He raises 2 issues on the appeal. And I'd like to begin with the systemic concern that we raised about the record keeping that is subject to the Rule 55 violation that we allege in the district court. So the Northern District has a local rule that tasks parties with the retention of exhibits. That's contrary to what Rule 55 requires. District courts are the repository of court records. That is because...
Mr. Hillis, I mean, you make this argument, and, you know, it's kind of an interesting theoretical issue, but
Yeah.
I have a host of problems with it being raised in
Here.
this format, in this vehicle. One of them being, I can't see what impact it had at all on your client since you got the records. Another being that this was never presented in any way to the district court, so here it is parachuting in on us. And a third being the fact that the integrity of the rules that the district court uses are the sort of thing that, you know, you take to the executive committee, you work with these rules. And so, and there may be more, but those are my big 3, I guess. So I'd appreciate your addressing them.
All 3 good ones. I'll try to make sure I touch on them, but please redirect me if I miss anything. So first of all, if things are commonly seen, they may not be evident in their defects. And so for years and years, this local rule's been there in the district court. No,
And in many district courts. I mean, I looked around, you know, somebody I was talking to about this, you know, said if there's a major city in the district, they have this rule.
yeah, I would feel better about the comfort in numbers idea if we're all using the rule correctly. But if the rule says that you're not allowed to do this, the fact that everybody is doing it that way makes me more concerned, not less. So strength in numbers doesn't mean much to me if everybody is doing something wrong. I would say that the rule says this is being done wrong. There is a separation of powers problem that's evident if the judiciary, through the clerk's office, is responsible as a neutral party for maintaining exhibits, and we are instead tasking parties, which in this case mostly means the government as the executive is retaining the exhibits, because when we reach out and try to get the document through the public right of inspection through the district clerk's office, we're told go ask the government. Now, as for whether we got this,
I mean, if you don't happen to have been trial counsel and you couldn't,
I almost never am.
you know, I'm aware
Yeah,
of that.
no. It's okay.
But the fact is, trial counsel would
Right.
sometimes pass it along to appellate counsel.
You're absolutely right. And here, we would have an additional safeguard and feel better about how everything came in if the trial attorney in the district court level, Judge Wood, came back in the case. But the trial attorney was never brought back in on the case. So when the order goes out to say, identify what the exhibit is and send it in, we only have the government speaking. We don't have defense attorneys saying on the district court level under Federal Rule of Civil Procedure, Criminal Procedure 10E, I think it is, that yes, this is the document, we agree, or this is the video, we agree, and it goes back. Rather, the district court just receives a copy from the government and accepts it. No review by the district court even to say this is the same one.
But, you know, is there any reason at all, aside from, you know, kind of the bad person view of the world, that the documents that you received are anything but the documents that were in the case?
I'm in a poor position to answer that because I wasn't in the district court when it was played.
And plus, I mean, where's the injury here?
Well, the
I
public right of
mean, it's
inspection.
a practical impact.
That's kind of what I'm trying to get at.
Yeah, just
among other
it's
things, yeah.
negligible,
And
just negligible.
Before we express opinions about this,
Sure.
shouldn't we be hearing from the district court and the clerk?
By all means, I don't see that they made any effort to intervene here. I think that they were content with the representations by the government to defend its interests here. But this is a problem that's going to go in uncorrected, and so we do have an injury because there's common law right of inspection of public records. We're supposed to be getting file stamp copies to ensure as defense attorneys that we know, right, trust but verify. How do we know we got the copy directly from the clerk's office?
But didn't you receive a true copy of the exhibit that was actually filed with the court?
I received the copy that the government provided me, Judge. More than that, I cannot say. I'm not trying to disparage Ms. Chung. She's been excellent. So is Ms. Mavius, who provided the copy. Problem is, we don't have a file stamp copy. Imagine if this is DNA evidence, if this is something else. These are very serious systemic concerns. You may say this is less so here because it's different evidence, but on the whole, we should require, pursuant to Rule 55, that there is one record keeper, and it is the clerk.
But you're coming to the wrong forum, you know,
exactly.
that you could file maybe mandamus, or you could tell the Rules Committee that they need to clarify Federal Rule of Criminal Procedure 55 to.
All true. We could
you know,
also ask the court to
that
exercise
would be
its
what I
super-
would think, you know, after 6 years in the standing committee, the committees are open for business on this sort of thing.
But the court-
And you'd get a full discussion instead of this highly speculative, you know, and I'm sure you don't mean personally to disparage anybody, but, you know, the integrity of the government's files is at issue here too.
It's not an issue. It's just unknown that I have the copy that the court itself relied upon its sentencing and would know differently if it is a file stamp copy, like if it was a piece of paper and it said this is the record. I know because of the stamp.
But you
And
know,
Judge-
you're going backwards in time. You know, we say file stamp copy, and we're slowly losing pieces of paper in the system anyway. We have EMCF and we have, you know, everything.
True, but they're labeled, Judge. That's how I know as a record when I get it off the docket that
Do you
it came
wanna-
from the clerks. But if I may just say one last thing.
Sure.
Put all those things aside. Say that mandamus was a vehicle. Say that there was another vehicle. Write the rules can be all true. But there's also the supervisory powers of the court that allow the court, even sua sponte, to jump in on this if they
Only
think there's
when
a
we,
problem.
I mean,
Oh
we
my
would never
gosh.
do that unless we thought there was some prejudice.
And we'd have a war.
I beg your pardon?
We'd have a war with the district court.
I'm not certain that you would. I
Oh,
don't
but-
see why there should
With
be.
drugs, guns, and money?
Only asking about documents. So if we were to say what the
Why?
rules should be,
Why are you only talking about?
sure, I'll say, because these are easily kept records. So if we're talking about physical evidence, we could have a different rule,
Well, but we have one Rule 55, right?
which needs to be complied with here. And if we're to say
But
that there are
does it-
exceptions and there are reasons to exercise them, they would apply perhaps to CP, to guns, to physical evidence, but none of that is the case here. And by and large, the exhibits that we get consist of documentary evidence and the occasional video. This is not hard. This is easier. As a matter of fact, for all the times the court has to issue orders and say, please, district court, clerk's office, include now the exhibit that was referred to and not part of the record. I hate to say cheekily that we are here to help, but we are here to help.
Let's
Because no
talk-
longer do you have to get the order out, do you have to tell the government to go ahead and submit or do anything else. This is all done easy peasy on the district court level.
Let's
Now,
talk about Mr.
Let's.
Hibbett, please.
the reckless flight,
Inducement. Inducement.
so the reckless flight, we think is pretty clearly a matter of government burden and accounting for the appropriate facts here in this case. And so when
And
it's
the district court recognized this as an issue of fact, but he resolved it adversely to your client. You know, he said,
Yes.
you could see on the tape that when they make this right turn, you know, off they zoom, and by that time they know it's police who are in pursuit.
Very true, Judge. But we look at the Hayes case from the Sixth Circuit. It says that you must know that they are police when you are counseling, inducing, encouraging, et cetera, the
That's what,
reckless flight.
isn't that what the judge found, Judge Johnston?
Well, if we look at first of all, I would start with paragraph 17 of the PSR that describes what happened. And in paragraph
got that
17,
right
we
here.
don't have accounted for the keep going. The keep going is, according to paragraph 17, in our view, in our reading of it, that the lights have not been lit by
Yeah,
the
but
police.
what about, look, we have an objective video
Yes.
that reveals that the chaser flight occurred immediately after the police lights were activated.
Well, that's true. But
Right, so that with Holloman stating that Hibbert said, keep going when a car was chasing them, or, you know, the PSR says during the flight, I mean, taken together, couldn't the district court properly conclude that when the statement by Hibbert telling her to keep going occurred when the police sought to pull them over?
Well, Judge, just to disagree slightly because I must. Paragraph
What?
Yeah.
Mr. Hillard.
Paragraph 17 of the PSR describes what happened, and it's not based on the PSR anything other than my client is concerned that they might be followed. It's an unmarked car. He doesn't know who's in it. He's had trouble in history with people before. He says to her, keep going. She then speeds away. They activate their lights. That's all fine. But the crucial thing there is accounting for when was the phrase "keep going" uttered. And if
Right,
keep-
and he finds the sequence to be a bit different from the way you just articulated it.
But if you even look, it's not accounted for ultimately pages 27 through 29 of the appendix describes where he sets forth all the reasons for why the reckless flight, the enhancement should be imposed. But it's only at the tail end he then says, and he said, keep going. But it's not accounting for once you've adopted the PSR, which includes paragraph 17, that the sequence of events as laid out in the PSR is that keep going is said, then the lights go on. And so turning on your lights is a pretty good signal that somebody is the police, right? Flashing a badge. But if you...
I read the district court as saying, I'm not taking any particular version of this as gospel, but particularly with the cite to the Lubman case out of the Fifth Circuit, and the lack of any other apparent motive for the driver to flee here than the fact that Mr. Hibbett had a gun with him. Put all that together, and it seems like a not unreasonable inference. So.
Well, it was by implication almost that the driver was under duress. That was never established. The district court shouldn't speculate that these two people who know each other, one of them having a gun and not knowing at first who the vehicle is behind them, that she wouldn't have any reason to be concerned for her safety, etc. There's nothing to suggest duress between these two friends. They could have brought in the witness and testify. That would have been terrific. If Ms. Holloman was brought in, I understand she's deceased now, so that is not a possibility. But again, the burden was on the government, and if the sequence of events show a stop, a concern that you're being followed, you say keep going, as my client says to the driver, he's the passenger, and the driver goes, then the lights go on. We don't have the inducement, encouragement, etc. under 3.1.2c, I think I got that correct, that is necessary under Hayes. The sequence is important, and if saying keep going occurs before the lights go on, I don't think the government's met its burden. Nothing else. Thank you.
Thank you, Mr. Hillis. Ms. Chung. Hello.
Good morning, Your Honors, and may it please the Court. Ashley Chung on behalf of the United States. This Court should affirm the District Court's judgment and sentence. And starting where defense counsel left off, here the District Court did not clearly err in finding that the defendant induced the driver to flee from the police, knowing that it was law enforcement behind them.
But look, given the lack of certainty as to whether Hibbett instructed her to keep going after the car activated its police lights, what evidence is there of encouragement or inducement that occurred after they were aware that it was a police car?
Your Honor, I think here the record speaks to substantial circumstantial evidence that there was inducement and counseling that occurred when the defendant knew that it was law enforcement following behind. So first of all, the District Court made these factual findings, including that the officer's lights were in fact activated and then that the car took off. The District Court also found that, contrary to the driver's claim in the recorded jail calls, that she and the defendant knew that it was police that was following behind them because the lights were on, as opposed to her claim that in fact the lights had always been off. The court also found that the defendant had an illegal gun in his lap while the driver was driving, found that the defendant had a history, I think referred to it almost a modus operandi of fleeing from law enforcement, and the court specifically found, and this is at Government's Appendix 52, defendant was the one that told the driver to flee, to get going, to keep going. And
yeah, but the prospect of Hibbett being charged as a felon in possession well, might have motivated Holloman's reckless driving, but on what basis can that motivation be attributed to him? Isn't it just as plausible that she did not want him arrested for her own personal reasons?
I think that's another permissible inference that could be drawn from the record, but where there are multiple permissible inferences that are supported by the record, the district court choosing one over the other does not amount to clear error. And here, going back to the record, in addition to the defendant having the gun out on his lap while the driver was driving, there's also the ATF special agent's testimony as he was testifying about the call, and this was in response to a specific question from the district judge, that the defendant told the driver to basically keep driving and get away from the people chasing them. And that was in response to the court's question of what, if anything, did the driver say on the jail call about what the defendant told her while she was driving. So while there may be there isn't a specific finding in terms of the sequence of events and the sequence of when someone said keep going or might have also repeated keep going later on, here there was certainly enough evidence in the record for the district judge to reasonably infer that it was more likely than not that the defendant induced the driver to flee knowing that it was from police.
Well, and it's that last part of it. It's knowing that it was the police. Now, if some, rival was behind them trying to chase them down, some private party, this enhancement would not be proper.
That's correct, Your Honor. And I think the district court explicitly recognized that below during the sentencing hearing and also then referred to it when it cited to the Lugman case from the Fifth Circuit as having very similar facts. Mm-hmm. So unless there are other questions with respect to the guidelines enhancement, I'd like to turn to the other issue up on appeal. And here, the government submits that this court lacks jurisdiction to address the defendant's complaint with the clerk's office for all of the reasons I think that the panel raised in its questioning to defense counsel. I think here, perhaps starting with the standing issue, we don't have an injury in fact here. As this panel properly noted earlier, here not only did the defendant already have these video exhibits down below through discovery, as was confirmed on the record at sentencing, but then once again, at the time that his case came up on appeal, and exactly as the local rules contemplated, appellate counsel here was able to obtain a copy of the exhibits from government counsel and proceed with this appeal.
So why don't you stamp them?
Honestly, Your Honor, actually, with video exhibits, the way that the process now works is that digital evidence submitted to the Northern District of Illinois is submitted through a website portal. And so it gets uploaded electronically, and then it's actually apparent on the docket now in the district court case, since the district court granted the government's motion to supplement the record. The process is then that you can contact the district court and request a copy of the electronic exhibits, and once you pay whatever fees may be applicable, you get essentially a link to download it. So there's not an indication necessarily that it would be file stamped in the formal sense, but it would be coming directly from the clerk's office. So I think as this panel alluded to in its questioning, file stamping itself is, I think, not a thing of the past, certainly, but something that applies more when it comes to documentary exhibits as opposed to digital evidence here.
I would assume that on those issues, the press would be a pretty interested set of parties.
Yes, I think that's true, Your Honor, and certainly the case law and authority that exists relative to the access to exhibits in many instances deal with the right of the press. But I think importantly, the case law states that the right to inspect, access, and copy judicial records is not absolute, and that's in the Nixon case from the Supreme Court. That Supreme Court went on to explain that the few cases that have recognized such a right agree that the decision as to access is one best left to the sound discretion of the trial court in light of the facts and circumstances of the particular case. And so, for example, in the Nixon case, the district court had said that it would retain custody of various tape recordings until after the trial was concluded. And the Supreme Court said that that was a decision that was within the discretion of the trial court to make. I think that's precisely what Local Rule 79.1 allows for here. It sets the district court up as the gatekeeper for what's going to be made part of the record, both in the district court proceedings as well as on appeal.
So can I ask you, as you understand Local Rule 79.1, would predecessor defense counsel have had an obligation to retain these exhibits?
I think not under 79.1. I would expect that there would be some sort of ethical rule that would have any defense counsel responsibly maintaining records for his counsel so long as they may be necessary to
So
potentially.
even if you're not still representing the person, would you think that would encompass, just a change of counsel on appeal, which happens all the time?
I think there may be some other rule, but 79.1 I think does not put that responsibility on defense counsel. The responsibility to maintain the exhibits and hold them in custody lies with the party that produces the exhibits in the first place. And so here it's the government, because the government was the one that provided and submitted the government's exhibit A and B to the district court. In a different case, if a defendant were to present exhibits, then it would be defense counsel's responsibility. And in civil cases, it would rest with whatever party happened to introduce those exhibits. And I think in that way, the rule also contemplates that it's going to be the party who relies on those exhibits, who introduces them into evidence, who then has to bear the responsibility of maintaining them, or if they fail to do so, would then bear any consequences or fallout for violating.
So if the press came to you, the U.S. Attorney's Office, and said, we want to see the exhibits, what would happen?
So in speaking with our office's press representative, I understand that requests from the press are relatively common, particularly in high-profile cases. And as a matter of practice, the practice of the U.S. Attorney's Office, at least in our district, is to make the court, the district judge, aware of the request, to indicate that the government, has no opposition to the request, and then it's just assuming that the district court also says that they have no issue or don't want to place any restrictions, to then promptly provide any exhibits that were used in a proceeding or already introduced into evidence to press who requests it.
Thank you.
And so here, in addition to the lack of standing, so the fact that defendant has no injury and any injury that may exist is not fairly traceable to the government, I think as the panel noted previously, here there's also no underlying district court decision or proceeding that's subject to appellate review under 1291. So I think for all the reasons discussed today, as well as the reasons set forth in our brief, this issue is not properly before the court in this appeal. And unless the panel has any further questions, we'd simply ask this court to affirm the district court's judgment and sentence.
Thank you, Ms. Jung.
Thank you.
You used up all your time, Mr. Hillis, but come on up. You come such a long way. You asked for 2 minutes. Would that do it, or?
Thank you. So, in no particular order, prior defense counsel doesn't always keep exhibits and they don't always respond to appellate counsel's requests. We can avoid any problems on that end if we can just get everything that we need through the clerk's office. I understood the government just to explain how the clerk's office does have a procedure to upload materials and keep them, therefore should be keeping them now and making them available presently. That's not happening, and so the Rule 55 violation to us seems fairly obvious. And under Nixon, as the government mentioned, the Nixon case, what ground would allow the district court to deny defense counsel, especially appellate counsel, access to records, or to defense counsel defendant access to exhibits that were relied on by the district court to impose sentence? I don't see.
But you weren't
Nixon as a
denied
barrier.
access, though. I mean, you got the access immediately upon request.
I never got the file stamp copy, Judge, which is the official court
But
record that should be
Ms.
provided.
Chung was just
Do that
explaining there
anymore.
is no such thing, with all of these uploads and, links and stuff. There's no file stamp.
But there is. Yes, I disagree, only because if I am in the district court and I have a video and there's a sentencing judge, I would say to the judge, here's a copy, I'm providing defense counsel a copy as well, I ask to be marked as exhibit so-and-so, retained by the court, play the video, now the copy is in the record. That's it. It's not hard and it should be done. And so then we all know, as the appellate lawyer, as the appellate panel, that we're receiving the real McCoy. Not to disparage, not to cast doubt, but this is how you know, because it's done this way as a matter of practice and rule. So as for injury is presumptive. You have public right of inspection. The court is supposed to contemporaneously make the materials available. It didn't. Standing, as a person who's injured, public right of inspection, you have an injury jurisdiction. Once there is an order, and the order contemplates the sentence in turn contemplates the evidence under Berman, the Supreme Court case, that judgment reflects something that can now be appealed not just to the decision
but also to the records that were relied upon by the district court. And then last thing, the government still in its explanation of what happened below does not adequately account for, pursuant to its burden, the timing of the events and the necessary and important part about keep going. If it occurred after the lights went on or before the lights on is the essential question. And if the evidence in paragraph 17 of the PSR says it preceded the lights being indicated, then under Hayes, my client doesn't know that they're police and the enhancement shouldn't be imposed. Thank you.
Thank you. Thank you so much, Mr. Hillis, and thank you so much, Ms. Chung. And case will be taken under advisement. And don't ever forget that Mr. Hillis did not mean that to be personal.
I certainly don't take it.
Okay. Bye. Okay. Case number 22-2932, United States versus Johnson. Mr. Boulay?
That's correct, Your Honor. May it please the court. The evidence in this case should have been suppressed for two reasons. First, because the officers who performed the traffic stop at issue unreasonably prolonged the stop, making it unconstitutional. And second, because the officer's inventory search was pretextual and thus constitutionally infirm. To my first point.
So before you start on your first point, let me just say, usually when we see these Rodriguez kinds of claims with stops, especially when there's a dog sniff, it's because the officer is diddling around on his squad computer for 15 or 20 or 25 minutes while a dog officer comes. But as I understand it, Officer Haber had the dog with him all along. I don't see where the dog extended this stop by a minute.
That's correct. Officer Haber had the dog in this case, Your Honor, but the real crux of this case is that Officer Haber, during the evidentiary hearing below, admitted that he abandoned the traffic stop mission to perform the dog sniff and when he called for backup. And that second officer, rather than continue that traffic stop mission, so continuing the typing out
So it's the time waiting for the second officer you want to focus on?
No, what we focus on is the absolute break in the processing of the traffic stop mission.
So sending the message.
No, Your Honor. It's the fact that he testified that once the second officer arrived, he had the second officer removed Mr. Johnson from his vehicle. So that was they removed Mr. Johnson, which is a safety precaution taken to facilitate a dog sniff.
But by this time, he already knows that Mr. Johnson has some problems. You know, he has a suspended license, a prior conviction. You know, those facts are known prior to calling for the backup. So, you know, I'm just trying to figure out at what moment in the proceedings was he doing something he shouldn't have done, because sometimes you start out, you know, just with a minor traffic stop, but then other things get uncovered as time goes on.
Correct. And there was nothing here that was uncovered. And just to, I guess, clearly make my point is he was waiting.
Well, the suspended license and the prior conviction, he didn't know that at the moment he's pulling the car over, I don't think.
That's correct, and we're not challenging the fact that you know, he spotted the lapsed registration of the vehicle, and that was reason to initiate the stop.
What was the timing of the call for the tow truck developed in the district court?
No, we did not develop that in the district court, but we do have the video evidence here, and it's clear at, I believe, around minute 54 of the video that is when Officer Haber called for the tow truck, which occurred, of course, after the dog sniff. And so what really occurred here is when you look at the Supreme Court standard in Rodriguez, they explained that even a de minimis detour would be enough for a constitutional violation.
But why is it a detour if there's already reason to think that there are additional matters to be looked into other than just the traffic stop? I mean, if the only thing, if he was just sitting there, you know, staring out the window, you know, playing a video game on his phone, you know, whatever people do, then I could see, all right, you know, he's delaying, what's the point? And maybe he says he's delaying, he has a hunch that once the dog sniffs, that would all be a different case. But I see this as a case where you're not really challenging the initial decision to pull him over, I gather.
Correct.
Okay, so that's fine. So as soon as that happens, he starts talking to the guy and processing things, but he finds out that there's this misdemeanor level problem that Mr. Johnson has. Well, that entitles him to deviate from any traffic related reasons and explore that. That's when he decides he needs to call for the backup officer. Nothing seems to take all that long. But he's allowed more time to pursue a non-traffic purpose.
Correct, but there's no evidence that the scope of the stop should expand to investigating criminal activity such as that he's trafficking drugs. And
no, I understand that part, but first of all, as soon as he finds out about the suspended license and the prior conviction, I assume you would agree that the officer is within his rights to tell Johnson that he can't drive the car away from the site.
Correct. We're not challenging that action.
Yeah.
What we're challenging is the fact that whatever the scope of the traffic stop was, including the items Your Honor just mentioned, that's within the scope. But the second officer gets there and he drops everything. No one is investigating those issues any longer, and he decides, I'm going to perform a dog sniff. He has the second officer facilitate that detour.
And this is like within minutes, if not seconds, of Officer Frankie.
That's correct, the second officer, Your Honor.
Who
Our
shows up.
our argument really, it does hinge on the fact that the Supreme Court explained even a de minimis detour, so referencing the Eighth Circuit's decision that they reversed in that case, even a de minimis detour was enough. And so even though we are potentially discussing seconds here, Your Honor, that was rejected in Rodriguez.
Rodriguez was, as Judge Wood indicated, factually quite different. You're waiting for the dog, and we've all seen the cases with the text messages. Hurry up!
Correct.
I can't delay this guy much longer. That kind of thing. We've seen those.
Get here.
But this is when are you going to get here? I guess I'm struggling as well. But let me ask. Once it's clear that the car is not leaving with Mr. Johnson, it's hard for me to see anything is prolonging the stop.
And that's the second argument, Your Honor, which is at that point it would have been an inventory search. And so what we have is at the evidentiary hearing, again below, Officer Haber testified that he ordered Mr. Johnson out of the car. He decided that he was going to impound the vehicle. And the first thing he did, he said, I'm going to perform an inventory search. And step one was to run the dog around the car. And that is evidence of a criminal investigatory pretext to perform that
But
search.
it's not even a search, though, right?
That's correct, but it's certainly the purpose of a dog sniff is solely, especially with this dog, which is trained to detect drugs and other contraband. The sole purpose of that is to try to suss that out, and the purpose of an inventory search is to produce an inventory, and the two are counter to each other.
I don't know that they're quite that far apart, though, because you run the dog around. Suppose the dog hadn't alerted on anything. Then, you just kind of search the car. Obviously, you don't try to rip it apart and find secret compartments and all the rest of it. With the dog alerting, he's been told, as I inventory this, there is more here than meets the eye. So, I don't know.
And that's correct. And I would point the court to our discussion at the end of our opening brief about how this does create the situation where if you find an officer doesn't think he has enough to extend a stop, but he does have enough to potentially tow or impound the vehicle, he could kind of get out of the strictures of Rodriguez and escape the strictures of the inventory search doctrines by just performing the dog sniff. And so
if he doesn't delay things by doing that, then...
Well, no, because, Your Honor, respectfully, he could just say, well, I was going to arrest him anyway, or he couldn't go anywhere because I'm taking his vehicle, therefore I can extend the stop as long as I want, and that would be problematic.
Well, suppose he had put Mr. Johnson in his car when the second officer comes, or in the second officer's car, says, here's Mr. Johnson, drive him off, to the local station, and I'll stay here and until the tow truck arrives. Nothing wrong with that, right?
Well, what's wrong is from the inventory search perspective, Your Honor, then if the first thing he's doing to perform his inventory search is performing a dog sniff, then that would be, again, he's not performing the inventory search to produce an inventory. He would be looking for criminal.
And,
Go ahead.
well, it's a little different. It's both a logical and, or I should say, logical, logistical, and safety matter. Didn't the officers need to remove Johnson from his car, secure him, in the safety of a police car before conducting any inventory, particularly, you're at a side of a highway at 11 o'clock at night.
We agree, but if the purpose of removing Johnson from the car was to perform the dog sniff, that's precisely what the Supreme Court warned about in Rodriguez. But
how does it, if for safety reasons, if for logistical reasons, you're doing that, so the dog runs,
because the removing Mr. Johnson, looking at it through the Rodriguez lens, removing him would be solely to facilitate that sniff, which would be to facilitate the detour.
But let's say it was for both reasons. They don't want him to be killed on the side of the highway.
Sure, well, Your Honor, if the purpose of removing him was to perform the dog sniff, there's always going to be a problem there. But if the purpose was from removing him was that, say, the dog sniff wasn't performed, they were just like, we don't want you here because it's dangerous, then we'd have a different case. But I see my time's well expired.
You want to run away.
Just trying to be
I
respectful
can't
of the court's
blame
time.
you. All right, but you used up all your time. I will give you your 2 minutes.
Appreciate that, Your Honor.
Okay. Mr. Temkin, hello. Come on up.
May it please the court. Good afternoon, Your Honors. Eli Temkin for the United States.
I have a question that I really have been wondering about. What is the official policy as to when and where the vehicle inventory should occur? Such, is it by the officers at the site of the traffic stop or at the impound lot after the vehicle is towed? What is the official policy?
Your Honor, based on the policy in front of the court that was submitted as an exhibit, I don't believe it's clear where an officer needs to conduct the inventory search, but under case law, an officer does have some discretion in how to carry out an inventory. So in this case, there would be no problem conducting the inventory, as the officers did here, on the side of the road. Your Honors.
I had one more question that I was thinking about, and it's this. Does the record contain any explanation as to why Haber waited to call the tow truck?
I don't believe the record does contain any evidence as to why he waited to call the tow truck. He had a number of steps that he needed to take to complete the impound of the car. And so he took these steps. He conducted the inventory, he processed paperwork, and then he called for the tow truck once they were ready to get the tow truck on the scene and get the vehicle out there. There were a number of steps he needed to take, and that's exactly what he did.
Mr. Temkin, would you agree on different facts? Officer finishes the traffic stop and then says, now, but wait another minute while I run the dog around your car. That's a problem under Rodriguez.
Yes.
Okay. Because my question is, why is it any better if that happens in the middle of the stop, but it's an extra minute added?
What matters is whether it prolongs the traffic stop. So if there's one officer there and that officer takes a break from traffic-related tasks to conduct a dog sniff, that's not permissible under Rodriguez. But if there are multiple officers there and the traffic-related tasks are conducted contemporaneously with the dog sniff, which is exactly what happened here.
What was Frankie doing?
Deputy Frankie was
During the dog sniff.
putting Mr. Johnson into the back of her car, and that's
For what purpose?
she was putting him into the back of the car because it was cold outside. The undisputed testimony is that Deputy Haber got Mr. Johnson out of the vehicle so that he could conduct the inventory. Once he got him out, Deputy Haber asked Mr. Johnson a few questions, asked if he could pat him down. Mr. Johnson consented. Deputy Haber patted him down. Once they had taken that step, they had Deputy Frankie put Mr. Johnson in the back of her car because it was cold out. It was 11 o'clock at night on a January night.
So not because they had ascertained that since he had a suspended license, somebody was going to have to take him away from the scene anyway? Were they planning to do they just leave people in the middle of roads, or do they drive him somewhere?
Well, logically, he would have needed to go somewhere, and he wasn't going.
And he
to
couldn't drive his own car. That was the problem.
Exactly.
So, would it be a violation of Rodriguez if we had, as we do here, Mr. Johnson being put in the squad car for whatever reasons, and the dog running around the car at the same
Sitting
time?
down periodically.
Would it be a problem to conduct the dog sniff while they're putting him in the car?
Right.
No, it's not. Putting him in the back of the car is a permissible part of their traffic-related tasks under any number of cases, Lewis, Goodwill, for example, from this court. And while they were doing that contemporaneously, they ran the dog around the car.
Yeah.
Lasted 66 seconds, and Mr. Johnson recognizes, I believe in his reply brief, in his opening brief, page 17, that by the time Deputy Frankie got back to the truck, to Mr. Johnson's SUV, he had already finished running the dog around the car. So, for those reasons, the dog sniff was permissible, was conducted contemporaneously. Additionally, the truck wasn't going anywhere. It was about to be towed, and so even if it hadn't been contemporaneous, there just was no delay here.
So you date, or you fix the time of the non-drug investigation part of this stop from the time he pulls over till the time the tow truck arrives, and all of that time. I mean, I thought there was some evidence that Officer Haber was slow walking his processing of the papers.
There's not evidence that he was slow walking the processing before Deputy Frankie arrived and before they conducted the dog sniff. There's limited evidence in the record about what exactly Deputy Haber was doing, but the
Do we know
evidence.
how long he was doing it? How long from the time of the stop to when Deputy Frankie shows up?
She shows up around the 20-minute mark in the video, and the stop occurred around the 2-minute mark. So from when the stop occurred, Deputy Haber was speaking with Mr. Johnson until around the 7 or 8 minute mark, I believe, and then Deputy Haber went back to his vehicle, radioed for more information, put together paperwork. There's not much testimony because Mr. Johnson didn't raise this below, but you can hear in the video that Deputy Haber was typing during that time. There's no reason to think that he was dilly-dallying or delaying. Additionally, in his reply brief, Mr. Johnson has clarified that he's not challenging that period of time leading up to the dog sniff. He's only challenging the 66 seconds that Deputy Haber actually ran the dog around the car.
Thank you.
I'd be happy to speak about reasonable suspicion if the panel has any questions, or about the inventory search. If there are no questions, this court should affirm based on either the dog sniff or the inventory search.
Thank you, Mr. Temkin. Mr. Boulay?
Appreciate the extra time, Your Honor. So just
We appreciate you.
thank you. So just quickly, the government's theory here, again, runs runs right into Rodriguez's discussion, and that's on page 356 to 357 of that decision, where the court clearly explained that a safety precaution taken to facilitate a dog sniff is problematic for the same reasons that the detour to perform the dog sniff is problematic. So for that reason, we think that because there wasn't a continuity of the traffic mission, he dropped everything. He testified that he dropped everything to perform that sniff, even though it was a de minimis departure. That is enough under Rodriguez to cause a constitutional issue. And unless there's further questions, I'll rest on the rest in our briefs.
And you too were appointed by the court.
That's correct, Your Honor.
And you both have our deepest thanks for taking on the case and for doing such a good job with it.
Thank you, Your Honor.
Thank you, and Mr. Tenkin, as always, the government, thank you very much for the good job you did and do. So, thanks an awful lot. And we are going to go on. We're going to take your case under advisement, of course, and that was very nice to see you shaking hands. It really was. It happens too rarely. We're going to take the next case, which is the last case. Numbers 221360, 221761, United States versus Fox. And it's Mr. Mitchell, of course. Hello, Mr. Mitchell.
May it please the court. Good afternoon, Your Honors. My name is Gregory Mitchell, and I represent Ms. LaTanya Fox, Judge. She's actually in court today watching this procedure. So just wanted to let the court know that she's very much involved here. As pointed out in the brief, I initially filed an Anders brief after talking to Ms. Fox and going over the issues that I thought could be raised after we successfully pled and got what I felt was a very good sentence and response in the district court. But in response to that Anders brief, I clearly missed an issue with respect to restitution. And in the process of going back and doing this supplemental brief, learned a lot about restitution and how it has to be handled going forward. In regards to the brief here, I would just like to point out a couple of issues with respect to how the court should rule in reviewing the case here. As I pointed out in my brief, I thought the appropriate standard of review was an abuse of discretion because the issue of restitution was hotly contested in conjunction with the calculation for loss. In the cases that I had reviewed, it was clearly not a simply waiving the issue of the calculation of restitution. It was challenged, although our number, after consultation with my client, was clearly different than, and even the process of coming up with the restitution amount is totally different than what the court pointed out that was missed by me, which was respect to the Mandatory Victim Restitution Act. But notwithstanding that, the question becomes, did the district court essentially, because it simply used the abuse of the calculation that was provided by the PSR, was that an abuse of discretion to just assume that that was a calculation and dismissing, which is why I argued that it should be an abuse of discretion standard, which is a little bit more favorable to Ms. Fox.
All right, so Mr. Mitchell, suppose we do see it your way and use an abuse of discretion standard. As I read this record, the district court looks at, several different materials, the indictment, the kinds of things that she said, and sees this as a scheme. We need to define the scheme, of course, given the nature of the offenses of conviction, going all the way back to 2013. And the district court also says, so it makes that fact finding, that's when the scheme begins. And it also appropriately, because it's restitution we're talking about, not sentencing length, limits the transaction it's going to look at to the ones in which she was personally involved. You know, this isn't, you know, irrelevant conduct, you're being responsible for stuff that other people did, because that's not restitution. But what's wrong with her methodology? What evidence is there that it was so far afield when it found that the scheme goes all the way back to 2013 that
Well,
there's reversible error?
as this court pointed out in Wood, I believe a decision authored with Justice Hamilton, is essentially, it's a question of what is the offense of conviction here, is where you start. And because
Well,
there
the
was,
scope of the scheme, but nobody focuses the district judge on that terribly well. But it does nonetheless make findings that this goes back to 2013.
yes, he does, Judge, and I point that out in my brief at page 11. The district court specifically said that he narrowed his restitution amount to those with respect to Ms. Fox alone, not part of any loss created.
That's what gets it down to the 1.2 million some
Yes,
level.
but the real question is that, again, what I learned is that the Mandatory Victim Restitution Act starts with the issue of what is the victim. It's a sort of a civil remedy, and in this particular case, there is one victim with respect to the offense of conviction, and that's MS. There aren't any others. This wasn't a conspiracy in this case that was charged here. She didn't plead to a conspiracy. The only question becomes is whether or not the judge deciding to look as he did to her initial conduct was an abuse of discretion, because he's using a formula to determine restitution which is outside of the scope of the Mandatory Victims Restitution Act.
So
And-
I thought in your brief you were arguing that there were two different schemes. I mean, we need to identify the scheme, but I couldn't see where the evidence was that these were two different unrelated schemes.
From the order that you provided, and the issue is that there could be a potential that even though the offense of conviction was different and separate, it's a possibility that the evidence was overlapping and there could be two schemes. So my brief focused on the fact not only that the offense of conviction was totally separate, but also that there was a separate scheme. In
But the
fact,
offense of conviction just focused on, you know, that one
the wire fraud, yes, Judge.
act of wire fraud that
But the issue with respect to the separate scheme, as was pointed out all during the argument, is that Ms. Fox had a tax fraud scheme that involved the education credit that began in 2012 and continued. The wire fraud scheme in this case was in 2016, and it was only with her disseminating information, not
she
with her.
sends the personal identifying information
Yes,
about
Judge.
this particular person.
And clearly, what was charged here, and again, I didn't understand it, and that was part of the issue with trying to craft an appropriate plea declaration. Her scheme was not charged technically from 2012 to 2015, and it wasn't charged at all. And so the question was, well, that's going to be part of the relevant conduct, and it's possible if we don't plead to the one charge that you clearly did, the government could easily supersede and add this whole other scheme with this evidence that they have, and we'll be in a worse position. So the strategic thing to do was to try to figure out how to essentially have her admit, which she did, what she clearly was charged with and did, and contest all the others. And yes, Judge.
Finish your thought.
So the question in preparing the supplemental brief was, what exactly was the scheme that the judge was focused upon? And it was clearly from the arguments on the sentencing hearing with respect to how to calculate the sentence, the actual loss, everything was focused primarily on the guideline calculation and the loss. And that was where the focus, and his sentencing for the restitution was also focused on that scheme as well, that you are going to be accounted for the relevant conduct. And that's how we focused on it. There was no issue with respect to the wire fraud scheme at all. And as I pointed out in my brief, it just wasn't there. No one raised it. And again...
So doesn't that point us in the direction of plain error review?
I think Plain error is what most of the decisions that I reviewed point out. I think in Wood and in Deidre, both of them all say plain error but the language is that the issue was not, there was no challenge to the restitution at all.
Right, and I will just say, speaking as an ex-district judge, that would seem to point in favor of affirmance. That is, the district judge here seems to have resolved all the issues presented to him.
Yes, and that's correct. Unfortunately, though, my understanding, and please correct me if I'm wrong, the Mandatory Victim Restitution Act statutorily is designed primarily as a sort of civil remedy. And even though the judge and the parties didn't do it, the restitution order must be pursuant to the statute. And so to the extent that the court has to apply the standard, the test for the statute, by choosing not to do that is an abuse of discretion, is why I pointed it out that way. But I believe also, again, the plain error reaches to the same result.
Even if we agree that the district court should have explicitly defined the scheme, how can we, do you think, conclude that the error was obvious, given that the plea declaration and the PSR broadly defined the scheme? And in the challenge to the restitution amount, Ms. Fox assumed the applicability of the broader scope.
Well, with respect to the plea declaration in particular, she pled to the particular offense of conviction, not the other charges. In regards to the broader scheme, it's clearly within the context of the relevant conduct. And that was strategic for a reason, because obviously what you want the district court judge to understand is that she's not minimizing her criminal conduct for calculating her sentence. You want to make sure she's accounting for that. But there was no indication at all, and there's no discussion really about restitution, which is why the district court sort of bifurcated it. Our argument was really about the sentencing issue. And the mistake was made is that once the restitution issue was separated out, I should have focused on the statutory definition of what and how you calculate it separately. I didn't do it. I know it now and plan to make sure that all my colleagues understand this.
Okay.
Thank you.
And you've used your time, but we helped you do that.
Thank you.
So we will give you the 2 minutes that you requested, Mr. Mitchell.
Thank you.
Thank you. Hello, Mr. Whalen.
May it please the court. Nathaniel Whalen here on behalf of the United States of America.
Can I start you, please?
Please.
Doesn't the record allow for the possibility that there were the 2 distinct schemes here, one encompassing the exchange of information with the group in this count, and a different scheme involving the systemic filing of fraudulent returns exploiting the education credit?
Your Honor, I don't think this record allows for that inference. At least it certainly does not plainly allow for that. The plea declaration. So the defendant admits in her plea declaration she engaged in a scheme to defraud from 2014 to 17. She admits that including fraudulent tax returns with these false education credits. She admits there are other means by which the scheme to defraud was effectuated. She's sharing PII with her co-conspirators. She's inflating business losses, inflating business income. We have a couple different ways the scheme was effectuated and the returns were fraudulent, but it is all part of the charged scheme. And the charged scheme was not 2012 to 2014, it was 2014 to 2017. That's what she admits. That's what Judge DiGiulio found by adopting the PSR at sentencing. That's also what he found in his statements to the court, or his statements during sentencing. The standard of review is plain error here. The defendant did not object to the scope of the scheme at any point, didn't object in filings, didn't object to the PSR statement, the section called the scheme to defraud. The only objection raised was that she should get credit for audited returns that she believed the IRS got back. The IRS, she believed, recouped money. The district court found that wasn't the case in the district court's order on restitution.
why should we be, straining to patch together a definition of the scheme from the PSR and the plea declaration, as you suggested in the briefs, when the district court is entrusted with that task and is in the best position to define it?
Couple responses. I don't think this court does have to strain. I think the indictment's pretty clear on what the scheme to defraud is. I think the plea declaration is pretty clear as to what the scheme to defraud is. And frankly, I think the district court is pretty clear about what the scheme to defraud is when he says at page 24, you and your co-defendants employed a scheme to defraud the IRS by preparing and filing phony federal tax returns. Among other things, it appears you utilized education tax credits that you knew were fraudulent to increase tax refunds. So amongst other things, the court acknowledged there were a couple different ways that this scheme was effectuated again, but it kind of honed in on this particular issue, the education credits. And that's all Ms. Fox is being asked to pay in restitution, the returns that she submitted that contains these education credits. That is the entirety of her restitution obligation. That's the $1.2 million. And so that is what the district court found was the scheme to defraud. She never objected to that being the scheme to defraud. I just want to address a couple other questions and issues raised in the opening argument. MS is not the victim in the case. The IRS is the victim in this case. They were the ones who defrauded out of millions of dollars through these nearly 700 tax returns. Though Ms. Fox pled guilty to one wire, this court's noted time and again that restitution applies to the scheme, not just the single wire. Most recent, or a case that both parties cite is Locke, at 643 F3rd 247, the court sets out that standard. That's not just the one wire that you're held responsible for restitution purposes, it's the entire scheme. Frankly, Your Honors, unless there are any other questions, I think we'd rest on our briefs and ask this court to affirm. Thank you.
Thank you very much. Mr. Mitchell, thank you. Mr. Whalen, thank you very much.
Give him just 2 minutes.
Oh, I'm sorry. I gave it. I'm taking it
It's
back.
right up there.
Oh, this is terrible. Oh, I am sorry.
That's right, Judge. I just thank you for the extra time. The real question, again, is the calculation of the restitution amount pursuant to the statute in this case, and the requirement that the district judge be very specific in identifying and demarcating the scheme. It wasn't done in this case at all, and as you pointed out correctly, that the record doesn't allow it to be determined by this court at all. Yes, there's language back and forth because it was hotly contested. This issue of the amount of restitution and loss was highly contested, and that's
But not
why.
in terms of scheme or not. I thought it was just contested because of refunds or audits or other sorts of things. I didn't see people making there were 2 schemes or 3 schemes, that type of argument.
No, and that was because of the way the plea declaration was actually accepted, which is the one charge, which was not a scheme, which was not a conspiracy. It was one wire fraud with the MS victim that essentially was a separate kind of issue where it was actually disseminated from Ms. Fox, not her doing the tax. So that was the focus. And again, the record is devoid of anything because the focus really from the district court was about the loss calculation primarily and the relevant conduct that should be accounted, not the Mandatory Victim Restitution Act. Unless you have any other questions, thank you very much.
And thank you again, Mr. Mitchell. Thank you again, Mr. Whalen. And the case will be taken under advisement, and this court is in recess.